ScottishPower Limited and others against the Commission for Dismissal, Revenue and Customs.
Yes, Mr. Hewitt.
Yeah. Good morning, my ladies and my lords, and welcome to Glasgow for those who haven't been here before. It's perhaps appropriate that the first advocate who would address the court in Glasgow would be a local boy.
Yes, that had occurred to me.
Yes.
I should say we're delighted to be here. We've got a very interesting week ahead of us, and this is a good case to start with, involving a company that's based in Glasgow.
Yes. Just before I start, I appear with Mr. Chacko for the appellants who are the HMRC, and my learned friend Mr. Goldberg and Ms. Ingalls appear for the respondents. Despite the Scottish flavour that Lord Reid referred to, this is an appeal from the Court of Appeal of England and Wales.
Yeah.
Both tribunals below, the first tier tribunal and the upper tribunal, found either substantially or wholly against deductibility of the payments in question on the basis of Section 54(1)(a) of the Corporation Taxes Act 2009. The Court of Appeal took a different approach and held that the payments were all deductible. It has always been common ground that the £1 element of each of the payments is not deductible. That is because it is accepted to be a penalty. And this this common ground is repeated in the respondent's case at paragraph 5.1.1. However, and I will come back to this later, there are a number of arguments put forward in the respondent's written case which, if correct, would appear to lead to the conclusion that even the formal penalties paid to the consolidated fund are in fact deductible. And it is quite difficult to see from the respondent's written case what principle precisely they put forward to justify non-deductibility of penalties. An interesting feature of this case, though, is that there seems to be no support from either party for the reasoning of the Court of Appeal. It is not HMRC's case, and I hope that has become plain from our written case. It is not HMRC's case that there is a judge-made rule untethered from statutory provisions that penalties are not deductible. And that seems also to be the respondent's position. In fact, quite vehemently is the respondent's position that paragraphs 1.9.2 to 1.10 of their written case. So we are in agreement about one thing, but I will obviously we'll obviously have to come back to that, because that was the basis, my submission, for the reasoning of the Court of Appeal. Essentially, they said because this was a judge-made rule of some sort, it had to be construed very narrowly and could only apply if you had formal penalties which were actually statutory penalties, rather than payments which we say, and the FTT found, perform the same function as penalties. Now, why is this case important and difficult? In other words, why are we here in the Supreme Court? First, we have an unusual situation. More than 100 years ago, the Court of Appeal decided that penalties were not deductible in computing taxable trading profits. This was based on orthodox reasoning applying the predecessor to Section 54(1)(a). And I'm referring, of course, to the case of Von Glen. In 1999, the House of Lords, through Lord Hoffman, concluded that the decision of the Court of Appeal in Von Glen was correct, but not for the reasons which the Court of Appeal gave. And Lord Hoffman went on to explain how the Court of Appeal ought to have reasoned the case. Unfortunately, he failed to explain clearly how his reasoning fitted in with the statutory tax provisions. And this has caused confusion, and we would submit the disagreement between the Court of Appeal and the tribunals in this appeal. So that is an unusual circumstance. Secondly, we have the approach adopted by the regulator, which is to impose a nominal £1 penalty along with a very substantial payment made either to charity or to certain classes of customers. It appears that this practice started around 2010. We can see that in the first tier tribunal decision at paragraph 30. And it is our submission that the court has to determine the true nature of that payment, referred to, I think, in decisions and in written cases as the redress payment, and how the principles which apply to the deductibility of penalties apply to those payments. So can I begin with the statutory and regulatory framework? And I can take this from the first tier tribunal decision, which I'm looking at in the key documents bundle. I think it appears in a couple of places.
Yep.
And it's paragraphs 3 to 10 of that decision, which is on page 136 to 137 of the key documents bundle. Under the, you can see set out there, under the Electricity Act 1989, it is a criminal offence to generate or supply electricity without a licence. That's section 4. And the authority can issue licences under section 6. And under section 7, a licence may include conditions. And then we have to move on to section 27A, which provides for penalties for breach of those conditions. And you can find the actual provisions in the bundle. I'm not going to take you to them at the moment, but you can, for your note, page 551 of the bundle has section 27A. 27B is a statement of policy. Provides for a statement of policy by the regulator. And that's on page 554. And 27E provides for appeals against penalties. And that's on page 558. And there are similar provisions in the Gas Act 1986, which is at page 589 following in the bundle.
Sorry, which page?
589 and following in the bundle.
So these were added in, clearly, at some stage. But before this, was there no penalties?
I'm afraid, I don't know the answer to that. I imagine there were, but I'm not sure
No, I
what the history
just
of that
noticed,
is.
obviously, they've been inserted at
Yes.
some stage. Yeah.
They were inserted before the period that we were dealing with. So, the statement of policy. I would just like to take you to the statement of policy, which is again in the bundle. It's page 489. And the first, although this is dated 6th November 2014, you can see that on page 502, the first tier tribunal found on the basis of evidence of a witness that this reflected the practice of the regulator before that date. And if we just turn to page 490, and if the court would just like to read over paragraphs 2.1 and 2.2 at the bottom of page 490. And then if you turn over the page, paragraph 2.4, if you could just read that, that sets out the way in which the penalties are calibrated. And the way that the penalty is made up is summarised on page 493, paragraph 5.3.
So, in terms of 2.4, a compensatory payment, although it's called compensation, it actually has a penal element in it. It exceeds actual detriment.
That's the key point, my lord. It has to exceed the benefit that the company may have obtained from breaking the conditions. Otherwise, it wouldn't act as a deterrent,
Yes.
which is the key. Which is what it's designed to do.
Yes, well, we're told it should significantly exceed both the gain to the regulated person and also the detriment caused to consumers.
Yes, yeah. But as far as deterrent is concerned, one imagines that the more important part, from the point of view of the company, is that they're always going to be worse off, is the idea, than they would be if they hadn't broken the conditions. And that's also reflected, as I said, in paragraph 5.3. And then if you just look at the steps, I'm not going to take you through the details of it, but if you just look at the steps set out beginning on page 494, calculate the detriment and gain. Step 2, assess seriousness. And then on page 496, consider aggravating or mitigating factors. And then 497, step 4, consider an adjustment for deterrence. And in 498, apply a discount in settled cases. And you can see on paragraph 5.26 on page 498, the way in which discounts are given for early payment, early settlement. And we will see that reflected in the decisions in this case. Exactly the same discounts were applied.
And under 524, the discount, it seems, reduces the penal element, but not the gain or detriment identified.
Yes, I think the idea is that even after the discounts, you should still be worse off. You're just more worse off if you delay in settlement. You will see that a reference also to something called consumer redress orders. That is a separate regime. It isn't. It wasn't used in the present case. My understanding is it may never have been used, but it is there. It's a statutory provision for providing for compulsory redress in certain circumstances. It was enforced in relation to some of the periods, some of the later periods in the present case, but it wasn't made use of.
But is your case that the same principle applies to consumer redress orders, or do you not have a?
We don't have a case because we haven't had to consider a consumer redress order, and I would not like to. I would not say that a similar principles would necessarily apply to them. My understanding of them is that they are more in the form of compensatory type orders. You will have seen that in this case, the first tier tribunal considered whether the various payments were compensatory and came to the conclusion that one could only say that about a small part of one of the payments, about £550,000.
Well, that reflected an actual loss.
That reflected actual loss to potentially to actual customers.
Yeah.
Whereas in the other cases, it was either paid to a charity, which would then be used generally, or when it was paid to consumers, it wasn't paid to necessarily the particular consumers who suffered the loss.
But under a consumer redress order, is that more focused on actual losses by actual consumers?
I understand that, yes, but as I say, I'm not sure it's ever been used. So, but I think that's right. So we say, looking at the statutory regulatory framework, that the acts on emissions which led to the payments in question made by the respondents were not akin to breaches of contract or tortious acts as alleged in paragraph 1.2.1 of the respondent's written case. That is one of the building blocks of the respondent's case, that this is really akin to breach of contract or tort. We say they were plainly breaches of conditions imposed on the respondents as a term of their statutory licenses, breaches of which can lead to statutory penalties. In fact, in one case, the energy saving case, it was actually a breach of the provisions of a statutory instrument. So it wasn't a licensing condition. And you can find that referred to paragraph 52 of the first tier tribunal decision. These are obligations, we would say, in the public realm rather than the private realm. I would like to now turn to the facts as found, or the important facts found by the first tier tribunal. And because it's important to understand exactly what the first tier tribunal found in this case. A number of the arguments put forward by the respondents appear to ignore the findings made by the first tier tribunal. So, can I start at paragraph 35 of the first tier tribunal decision? And this records the fact that the respondents were not compelled to enter into the settlement agreement. They could have refused and either accepted a penalty or appealed against the penalty imposed by the regulator. So that is the choice which my learned friend refers to in their written case. They describe that as voluntary. My submission is that that's not a proper characterization. They had a choice. They could have refused to enter into these settlement agreements and then had a penalty imposed on them. And we will see that the First Tribunal made a finding as to what would have likely happened in those circumstances. But it's not voluntary in the sense that they either decided to make it or not, and nothing else would have happened to them. Then paragraph 110. This is a finding. These are contentions that Mr. Goldberg put forward. You can see Mr. Goldberg's list above paragraph 108. His contention was that they were voluntary and a result in negotiation. The Tribunal said, to the extent that means without compulsion, we find the terms of the settlement, the amounts of the payments, were the result in negotiation. The agreements were not imposed. They agreed to their terms in the expectation that if they did not, a penalty greater than £1 would be imposed. And then paragraph 112, they find that the acts or inactions which gave rise to the redress payments were part of the trade's activity. Those were done for the purpose of earning income from the trade. We find that the payments were a consequence of not meeting the standards required of energy suppliers. We find that infraction of the standards is not uncommon, but that serious breach, as was the case in relation to the redress payments, is less common. And then they say we consider the breaches of the CO2 and complaints handling rules were practically almost unavoidable. Not able to say on the evidence, not able to say the same in relation to mis-selling or cost reflexivity. I'm going to come back later on briefly to this idea of practically almost unavoidable and the significance of that. But just to foretell what I'm going to say, what you can see is that the Tribunal came to that conclusion on the basis of the way in which the respondents were carrying on their trade at the time. In the light of that, it was practically almost unavoidable that there would be a breach in those cases.
Yes, I was going to ask about it because it seems curious if a license condition is impossible, if a valid license condition is impossible of compliance.
Yes, especially as these breaches were all regarded as serious by the regulator in every case.
But when they say practically unavoidable, they mean practically unavoidable given the way that the respondents carried on their business.
Were carrying on their business, exactly. Not as practically unavoidable for anyone. Yes. But we will say that it doesn't matter anyway, that you don't have to look at the degrees of avoidability or otherwise of the penalties. And then paragraph 115. Oh, sorry. While I'm here, if we look at paragraph 113, the contention, you'll notice that the important difference between the contention that's put forward and the finding by the Tribunal. The contention is the redress payments were made wholly and exclusively for the purposes of SP's trade. So that's the payments. The conclusion, the finding was the purposes for which the actions were taken which gave rise to the payments were wholly and exclusively of the trade. And that's an important distinction we will see when we look at the case law. And then 115, and you'll see from that that a statutory process was engaged in relation to the redress payments. That's the final sentence in 115. And then moving on to 134, at page 155, it's clear that the regulator intended the obligations to make the redress payments to be punishments. That's the finding in 134. And then, importantly, very importantly, 137, and it's the, about, if you just go down about 5 lines where it begins, but it seems to us that in each case, had a payment not been agreed, it is likely that even after any appeal, a penalty of the same order of magnitude as the settlement amount would have been borne, because it seems unlikely, in the view of Ofgem's attitude and the way the witness describes Spell's aims in settlement, that Spell would have settled if it had been given robust advice that only a very much smaller sum would have been successfully imposed. And then 138, in that sense, we regard the settlement to have been made in place of what might have been imposed, and so to have avoided a penalty larger than £1. And then paragraph 157, having gone through the, you can see under the heading compensation, having gone through the various 4 different cases, they concluded that only the 554,013 paid in the mis-selling settlement was compensation. The remaining payments were non-deductible penalties. So they concluded that none of the rest of them were compensation payments. And it should be noted, as you may have noticed, that the upper tribunal concluded that even that element, the 554,000, was part of a package which was all non-deductible. And that's paragraphs 95 to 101. Despite that, the respondent still refers to these payments in its case as being compensation. And that's at paragraph 5.4.9 in the respondent's case. Then 167, the infractions were plainly serious, but they wouldn't have led to the destruction of the business, is the point they're making. And then again in paragraph 168, we conclude that the activities which gave rise to the redress payments were not an egregious breach of the rules of the type that you had in mind, McLaren. They were part of the trade of Spell. They were for the purpose of enabling a person to carry on and earn profits in the trade. And finally, 170, where they concluded it was likely that the respondents agreed to the settlements for the purpose of concluding the investigation. One would imagine would be pretty much self-evident. So in the light of that, I want to deal with the important question of the nature of the redress payments. The respondents say that whatever basis there is for saying a penalty can't be deducted from trading profits, the payments, other than the £1 penalties, do not fall within it. They say that the imposition by the regulator of the nominal £1 penalties was the exercise of the regulator's power to achieve deterrence. The rest of the payment was made voluntarily, they say, by the respondents. This, the revenues say, is an unrealistic way to look at what has happened. These were all serious breaches, and it was the whole of the payments which achieved the deterrence effect.
So it's a package. You look at it as a package of payments that you can't isolate different parts of.
Yes, well, you certainly can't isolate the £1 penalty from
No, not
the rest
the
of it.
£1, but
The
the 500,000, or are you? Do you accept what the FTT said?
No, the 500,000 is part.
It's part.
We would. I don't think that was ever disturbed by the Court of Appeal. They didn't address that point. They took a completely different view, which was that
Yes.
none of them could be regarded as penalties. So I maintain that, but my point is that the deterrence is provided for by the substantial payments of redress payments, not the £1 penalty. In other words, the nature of the total of the redress payments and the £1 penalty are the same as a penalty would be, which is the purpose of deterrence. We would say that's clear from the FTT's findings, and is also the realistic understanding of what happened based on Ofgem's policies and the correspondence between the parties.
Exactly how did the discount actually apply then? If the discount doesn't apply to any gain or detriment that's been identified by the authority, how did it apply in this case?
What in practice, we'll see. I was going to take you to the document. Yeah. What it did was it applied to the
whole lot,
the whole payment,
the whole package.
The whole package, yes. I think, my lord, what they mean, my understanding of what they mean by that is just that they're going to look at what the detriment is, or the benefit, and the penalty is always going to be more than that, even if it's discounted. Yeah. In other words, you can't get an overall benefit just by paying early, for instance. I think that seems to be what they're saying. So even at the lowest level of penalty for paying immediately, which I think is what happened in this case, that would still be greater than any benefit, any financial benefit that could be identified to the companies.
Yeah. So the company is never going to be allowed to make a gain out of its breach of its obligations.
No, far from it. I mean, the idea is that it will suffer a detriment because the penalty, and in this case, the redress payments will be greater, substantially greater than the benefit. And that's inevitable. Otherwise, penalties would never achieve their purpose. Yeah.
So the discount was applied across the board to the whole package?
It was, yes.
There was a separate calculation, as it were, that there was still a penalty being imposed on the trader.
Yes.
And that no gain had been made by the trader.
Yes. Yeah. And in circumstances where they were just imposing a penalty. So before they had this great idea of having the alternative, before that, then they would calibrate the penalty in that way. And we will see that what they do in these cases is they calibrate the total payments, the redress payments, in the same way. I was going to take you to just one of them. They're all very similar. The complaints handling. If we just turn up page 417 in the bundle.
And complaints handling is one of the breaches that was practically unavoidable.
Yes, I think that's right. Yeah.
Sorry, can you give me the page number again?
Sorry, page 417. You can see at the bottom of page 417, penalty policy on early resolution. The Settlements Committee has agreed that a penalty figure of 23 million before any penalty discount is appropriate in this case, as set out in enforcement guidelines. Early settlement results in cases being resolved more quickly and save resources, etc. In recognition of the benefit of early settlement, the authority has agreed 3 settlement windows and discounts which should apply to the penalty figure of 2.3 million. And you can see over the page that those being set out in the table.
And at the heading of the letter, the SLC 25C 27.17, that's all relating to complaints handling.
Yes, exactly. That's the licensing condition number, I think. SLC, I think, is standard licensing condition.
But is this letter just relating to complaints handling?
Yes, it is.
Yeah.
There's a separate letter and there's a separate set of documents in relation to each of the 4 investigations. They were all separate investigations.
And it says alleged breaches, but did they find actual breaches, or?
I think breaches were accepted.
They were accepted.
Oh yeah, sorry. Yes, I should have made that plain. This is before the agreement. This is what they're putting forward.
By agreeing, they agreed the breach. They
Yes,
accepted that there were.
We'll see that in the notice of decision. Yes.
So this is the offer letter.
That's why it's headed exactly, my lady. It's headed without prejudice and subject to contract. Yes, it's the offer. And so over the page, they've set out the various payments depending on when it's settled. And under that, you'll say, we'll note that the total proposed penalty in the early settlement window is 18 million. At this stage of the settlement process, we were prepared to consider ScottishPower making redress payments to the value of 18 million, minus £1 financial penalty, on a date to be notified by the authority in the final penalty notice, in lieu of a full 18 million financial penalty. The Settlement Committee has expressed a view that such redress should be made, so far as is practicable, in the form of payments to ScottishPower's current and former customers affected by the issues that the authority has found in this case. Following this, any remaining redress should be paid to suitable nominated charities or other appropriate third sector organisations. If we are not able to agree on a suitable redress package, we will ask ScottishPower to pay this amount as a financial penalty.
So without any discount, it would have been 23 million. So then they say, well, the penalty with a discount will be 18 million, but then you can make redress payments to the value of 18 million and just pay £1 penalty.
Less £1, right, strictly speaking, yes. So the 18 million will then be made up of £1 plus 17 million. And the notice of decision for this begins on page 327 of the bundle. And the terms of the you can see, Melanie, in 1.2 that ScottishPower admitted that it breached the relevant conditions. And 1.4, they consider that a consumer redress payment will be of greater benefit to consumers than if a significant financial penalty were to be imposed. And then they set out the terms.
Can I just interrupt you for a moment, Mr. York? I hope members of the public who are sitting in court have had access to a summary of what this case is all about. Yes, you have.
Yeah.
Good. Otherwise, it must be mystifying.
I'm very happy to summarise it very quickly.
No. If they've got that, that's fine.
Okay,
Thank you, Mr.
fine.
York.
You will note in paragraph 1.7, it's provided that if they can't agree on a nominated cause, Scottish Power will pay such sums as a penalty to the Treasury via the Consolidated Fund. And then if we just look on page 329, going back to the point we're making about almost inevitable, if you just read paragraphs 1.12 and 1.13, you'll see what was said about that.
Just remind me, what does CHR stand for in the bullet points at 1.8?
I'm sorry, my lady.
In the on 1.8 on 328, it says SLC and then CHR.
All right, yeah. You'll find that, yes, on paragraph 1.1, my lady, it tells you. One is the standard licensing conditions.
Oh, and those are the regulations.
Yeah.
I see.
Yes, the implication of 113 is that they were practically inevitable given the way that Scottish Power was conducting its business, but they weren't in any other sense practically inevitable.
Yeah. And they could have done better, even so, suggested.
Because it arose from how they implemented their new billing system.
Yeah. Yes, it's one can have sympathy that introducing a large new computer system.
Yes, well, 113, they didn't do enough to identify and mitigate risks of disruption.
Mm. Yeah, that's the point.
And then they didn't respond quickly enough or take sufficient action to resolve the issues that arose.
Yes. And then the terms agreed are set out on, summarised on page 345. Which are the terms that we've already seen referred to at the beginning of the notice. But except there is a time limit imposed in 6.4 that if they haven't paid it within 2 months, they will pay the sums to the as a penalty to the Treasury. So this is, these factual matters is why the FTT correctly saw the redress payments as part of the taxpayer's punishment, I think described it as, but as punitive as a deterrent. That's at paragraphs 132 to 135 of the...
Sorry, I'm struggling to hear you, Mr. Ewing.
I'm sorry.
Paragraphs?
132 to 135.
Thank you.
Of the FTT,
the flight
is
path of Glasgow Airport.
Yes. Paragraphs 132, 135
of the first tier tribunal
FTT.
decision.
Right.
And indeed, save as to the amounts that were considered to be actual compensation, the 554,000, the FTT considered the whole amount to be penalties. That's the way they described them, paragraphs 130 to 131 of the decision. Because they were expenses that the taxpayers suffered due to their breach of the rules to which they were subject. So when the first tier tribunal described the redress payments as in lieu of or in place of penalties, as at paragraphs 136 to 138, they were saying that they took the place of a formal statutory penalty but had the same purpose and nature as far as its relevance for tax purposes. That's paragraph 139 of the FTD decision.
And what would have been the position if they had paid the 500,000 before any of this correspondence had arisen? So what would have happened if they recognised that they owed a debt to their customers and actually paid it? Would that be deductible?
If they recognised they actually owed the customer something because they had overcharged them, for instance,
Yes.
that would clearly be deductible.
So,
Well, it would either not come in, depending on the timing of when they
So
repaid it, but it would,
it's timing and compulsion from the enforcement authority that is relevant. Is that right?
it is the compulsion, but it is it is because the payments are not to compensate customers. They're as a form of deterrence, a form of punishment. That's the difference, my lord, between that and the situation that you're putting forward, assuming that it happened in advance of any regulation, of any penalty being threatened.
Yes.
It might all depend on the facts, but normally, obviously, if you do compensate them, and indeed, the point about these payments is that they're on top of compensation.
Right.
That's made clear also in the. I think I took it to you, but in the guidelines, the idea is that customers should be able to, if they actually suffered an actual loss, they should be able to get compensation as well as this. These are not intended to replace compensation.
What, even the 554013?
Yes, I think all of it. Well, the way that it's expressed in the guidelines is that it shouldn't replace compensation. If the 554 was actual compensation of actually somebody's loss, that may be if somebody was able to say I've lost £50 or £34 and paid it to them, not as part of this, then they would be able to deduct it.
Sorry, I don't understand that, because I thought that the 554013 was actual loss caused to those actual customers.
It was, but it was also part, as the upper tribunal accepted, it was part of the overall figure.
Yes, I understand that point,
Yeah.
but I thought you might be saying something different just then.
No, I don't think I was. I think
So we're still talking, as my lord said, a sort of a timing thing, that if they'd worked out before Ofgem was involved that
yes,
these people should be compensated this amount,
and they compensated.
and they compensated
Yes.
them, then you accept that that would be deductible.
But then when it
What
came,
is it that makes this different then?
absolutely. But then when it came to the penalty calibration, they would still have had the 500,000 would have been in the calibration because that would have been necessary to make it deterrent. It may have gone somewhere else, but it would still have been there.
I don't quite follow that. Sorry. They recognise in advance that they owe £500,000. They actually repay those people
Yeah.
£500,000, and they do that because there is a contract and they have a contractual obligation to do so. And why does any deterrence enter into that? If they do it before the investigation starts, why should there be any deterrence in relation to that element?
I'm not saying there is any deterrent in doing that. What I am saying is that when you then come to consider the penalty, then you would be deciding it on the basis of the position at the time of the penalty and deciding what was the deterrence then.
The position at the time of the penalty is they've repaid it voluntarily on an ordinary commercial basis. And
so that might have the effect of reducing, I wouldn't suggest necessarily pound for pound, but it might reduce the amount of the penalty when it came to it because the benefit might be
Yes.
less.
I
Yes.
see.
Good.
So
Yeah.
they would still have breached the licence conditions. They would still be subject potentially to a penalty, but that penalty might be mitigated by the fact that they've actually already compensated the customers. So it wouldn't be 554013 insofar as that represents the actual compensation due. It would have been some round figure, £20,000 or whatever, for breach of that, breach of those rules. That doesn't now need to incorporate an element of compensation, but still has to be a penalty.
Yes, and I think my point was it would come in. It would obviously be recognised in deciding what benefit ScottishPower have obtained from this, that they have repaid that amount because that benefit has gone, obviously. But that would be the same whether it was a penalty being imposed for the whole lot or the redress payments. They would be deciding at the time of imposing the time of the penalty, what is the benefit and what do we need to impose in order to ensure this is a deterrent. And we're assuming, my Lord, in your example, that the 554,000 was paid without the regulator being involved.
Yeah.
If they did it in the middle of negotiations, for instance, I think there might be different considerations applied as to what the penalty would be.
Yes. So, I mean, the example that my Lord put to you was of a situation where there was a legal liability on the part of ScottishPower to reimburse customers, perhaps because they had overcharged them.
Yeah.
And if they recognise that liability off their own bat and reimburse the customers, then that's a deductible expense of the business. Well, it has to be taken into account in calculating the profits of the business.
Whether you adjust the account, adjust the receipts, or whether you would take a deduction.
And even if there weren't a legal liability, I mean, say they had simply messed customers around by poor service, then they might decide to give them a goodwill payment of some kind.
Yes.
And again, if they do that voluntarily, that might very well be deductible for tax purposes.
Yes. It might be taken, and then it might be taken into account, although not necessarily pound for pound, in the decision as to what the penalty should be.
Now, you're distinguishing these payments because they're made as part of a settlement with the regulator, and they're only made because of the threat of an enormous penalty being imposed otherwise.
An immediate threat, a threat.
Yeah.
Yes, exactly. You can see from the documents that it was going to be, they saw that as a penalty, but they were prepared to accept the redress payments being made as an alternative to it.
And so the critical feature isn't whether or not there's a legal liability, and you're focusing, I think, on, we're going to come to Lord Hoffman, but it may be the nature of the payment, or it may be the reason why the payment is made.
Yes, it's the nature of the payment that it's very closely assimilated to a penalty, we would say, because it performs the same function. So all of the points that are made about what happens in advance, supposing you make payments, all of those would apply even if there was a straightforward penalty imposed by the regulator in the end. If as I said, if they didn't have this clever idea of redress payments, they'd be in exactly the same position. They'd be imposing a penalty in the light of the circumstances at the time when they decide on the penalty.
So just to make absolutely certain I understand the submission you're making, and that is that if there is a legal liability to pay, a trader recognises that legal liability, makes a payment voluntarily, that amount of voluntary payment is tax deductible because it's in the nature of wholly and exclusively for the purposes of the trade. But if it is also a breach, then that is taken into account in calculating the penalty that is imposed on the trader.
It would be late if a penalty was going to be imposed later on, if it was considered to be sufficiently serious, etc.
Yes.
That would be taken into account.
Yeah.
But that's a different transaction. Something happens later when the penalty is imposed.
You can't avoid a penalty for breaches of the law by voluntarily making a compensation payment. And
no, you won't avoid necessarily. Well, it depends on the circumstance. So you won't necessarily avoid the penalty by doing that. Even if you compensate completely,
Yes.
there will still be a penalty because, of course, the purpose of the penalty is deterrence.
Yes.
Can I ask a different question, Mr. Hewitt? The policy document that you've shown us and the paragraphs in the FTT decision go to the question whether Ofgem had the power to and was in fact carrying out its purpose of deterrence and punishment in making in entering into a settlement that included redress payments. But the Court of Appeal said that the only relevant power that Ofgem had was to impose penalties. And maybe you're going to come to that, but I didn't understand why the Court of Appeal didn't take into account the policy and the findings.
I don't know what that. I was going to come back to the Court of Appeal decision later. It may now be after lunch, but yes, I will.
Okay.
But yes, we don't think there's any. We do think they have the statutory power. Well, nobody said they haven't. They've got the statutory power to enter into these kind of agreements in lieu of the penalties, if you like.
You say they do have statutory power.
They do have the power to do that, yes.
The power or the statutory power?
Well, it all comes from statute in the end. Yes, they have the power derived from statute.
Yes, and the £500,000 figure isn't one identified by the regulator. It's requiring, when we look at page 345, it's requiring Scottish Power to pay 18 million, and that sum is to include compensation payments and a balance. And it seems to be up to Scottish Power to decide how much is to be the compensation element and how much is to be the...
Yes, that's right. So, exactly. So there wasn't a fixed amount of compensation, and anything that wasn't paid by way of compensation would be paid otherwise. Mm-hmm. I think that all goes to show that it's all part of one
So the
package.
554013 effectively came out of this 18 million.
Yeah. Is it the figure or part of the figure? If I'm looking at paragraph 6.3 on page 345, which is giving the breakdown of the 18 million. So is the £500,000 part of what appears in paragraph A?
The 554.013 was for mis-selling, not for
Yes, exactly.
not for the billings.
That's right, yeah.
So it couldn't have been coming out.
But the same thing in mis-selling, there was the same point that if it wasn't paid by compensation, it would have to be paid.
Well, but the FTT found at 149 that it was properly described as compensating customers who were missold.
Yes. But it didn't...
But they didn't receive the payments as damages for breach of contract.
No.
They were akin to payments
Yes.
as damages.
And there's a question mark as to whether they could have recovered as well on top of this.
I mean, it transfers across to every other aspect of law. If you break the law in one particular area, that is, for instance, the criminal law, take that as an example, and you recognise that you've committed a crime, you recompense the person, the offender, the victim, you're still subject to a penalty for breaking the criminal law.
And that's because the same policy considerations of deterrence apply. Yes.
I'm not suggesting there's a breach of the criminal law here, but I'm just using that as an analogy.
I think there is a strong analogy between the two because of the purpose of these penalties is clearly deterrence. The idea is so that people don't break the don't break the rules, if possible.
Is there a term in the supply agreement between Scottish Power and its customers I don't know if that's that the terms of that agreement are regulated, but is it a term of the contract with the customer that Scottish Power will comply with its licence conditions, or are the two separate?
I haven't ever looked
All right,
at
well,
such a
that's-
contract.
It's not relevant.
I don't know the answer, but
Yeah, okay.
they are required to comply with them under statute, so
Yeah.
I think that's probably enough. But I don't know. I'm not sure we've never had a customer contract in this appeal. Sorry, I was just about to go on to the upper tribunal, just to note that they upheld these findings at paragraph 69 to 86. And just particularly paragraphs 84 to 85. Perhaps if we just look at that in the upper tribunal decision. Where they upheld the FTT. There had been a challenge. One of the grounds of appeal to the upper tribunal was about whether the upper tribunal were entitled to come to the conclusion about it being in lieu of a penalty, putting it in shorthand. And so the summary 84 to 85 is why they upheld the decision of the FTT. And while we're here, we would also uphold the decision of the upper tribunal, which was on the revenues cross-appeal to the upper tribunal, that there was essentially a single deal to pay an overall sum. This is in relation to the 554,000. And that the whole sum had the same penal nature. And that's at paragraphs 95 to 95 to 100 in the FTT decision.
I see, and paragraph 98 tells us what the 500,000 figure
Yes.
actually was.
Yeah. That was where I was also thinking that there was an overall figure of which the compensation element was part, which was the £1 million, I think. So that was always going to be paid. If the compensation was less, then more would be paid.
It might be useful at some point, not now. You gave us the complaints handling calculation offer letter at 417 as an example. It might be useful at some stage to have the page numbers of the other
For the other
ones that made up the package.
Yeah, we can.
Not
Yes, certainly. Now, at paragraph 1.16.3 of their written case, the respondents assert that if these payments are assimilated with penalties, which we say they are, then damages for breach of contract and tort would also be similarly assimilated with penalties. We say that is simply incorrect. Damages are, in their nature, compensatory. They are designed, in the case of contractual damages, to put the other party in the position it would have been in if the contract had been performed. Or in tort, they're designed to put the other party in the position as if the tort had not been committed, putting it broadly. We say that there's no difficulty at all with contractual damages. If a trader enters into a contract in order to make profits in its trade, and it makes payments under that contract, whether by way of just operating the contract or if it has to be sued for damages because it has broken the contract, those are all deductible payments, because the purpose of entering into the contract was to make profits in the trade, so anything that flowed out of it would be deductible. And there was an example of that in the bundle, a case called Cosmotron, where there were payments made, I think redundancy payments under a contract were made after the company ceased to trade, and these were held to be deductible because they flowed from the contract which had been entered into in order to make profits.
That's not a payment for a breach of contract.
Sorry?
That's not a payment.
No, it's not.
Breach.
But that's a,
so is there an authority for actually payments just for a breach of contract being deductible, or that's just
well,
HMRC?
I don't think anyone's ever questioned
No, right.
whether they are. The cases have all been about payments where one example is a case called Falkirk. I think it's a Scottish case, in fact, where they had entered into a lease of a building for a number of years, had to pay rent. After a few years, because the trading was going down, they didn't have any use for the building, but they carried on having to pay the rent. And the revenue said, oh, you can't deduct it anymore because you're not using it in your trade. And the Code of Session said, no, they entered into the contract, the lease, in order to make profits. They're obliged under the lease to keep paying the rent, even though they can't use the building. Therefore, it's deductible. So anything that flows from the contract would be deductible. I don't think, my lady, there's any authority on contractual damages, but they would be if there were damages in the same. For instance, if they didn't pay the rent and they were sued, then they had to pay it, then that would be fully deductible.
Yes, I mean, that's not a particularly useful example because it's a liquidated figure. But you say, even if I promise to sell you a ton of lima beans or whatever, and I fail to, or the beans are rotten, and I have to compensate you, that compensation would still be deducted.
If it's a breach of contract, if it's a breach of contract and you have to pay, that would be deductible. Of course, in a number of cases, there is a complication of insurance which might cover it, so it might not be an issue at all. But if you did have to pay it,
so defamation payments also deductible.
well, that's why I was just going to come on to tortious damages, because they are more complex, and they're not necessarily deductible. There are cases, certain tortious damages are not. For instance, there was an old case where a trader defamed one of his competitors, and it was held, and he was sued in malicious falsehood or malicious libel, whatever, and had to pay damages for that, and that was held not to be deductible. That wasn't an ordinary incident of his trade. So it may depend on what the nature of the damages are. Now, the only case, I think, on libel, which is mentioned by Lord Hoffman and McKnight, which is the Herald case, the basis of that decision was a finding by the judge at first instance that I think he went as far as saying it was inevitable. If you publish a newspaper, you will libel someone, and you'll be sued for libel. And in fact, you couldn't operate a newspaper business without that. Now, whether that would be a finding that would be made in the UK today, I don't know. Libel laws have changed quite a lot, I think, over the last 20 or 30 years. But on the basis of that finding, the High Court of Australia, by a majority, I think, decided that they were deductible. very much as assimilating them to things like newsprint and paper that you had to buy, because it was an inevitable part. Now, that's quite an extreme case, that it would be said that tortious damages are an inevitable part of your trade. The other case is Strong and Woodfield, which I was going to come on to in a little while, which is the case about the chimney that fell on someone staying in an inn. And that was held not to be deductible by the innkeeper on the basis that he was acting in a capacity not as innkeeper, but as householder, it was decided. So a very subtle distinction was drawn in that case between the different capacities in which someone might act. It was also decided on the basis, and this is Lord Davies' famous dictum, which has been applied in numerous cases, on the basis that it wasn't paid in order to earn profits in the trade. So a distinction is drawn between payments that are paid to earn profits. I think it was described in one case as grist to the mill, and payments that arise from trade but are not paid in order to make profits. And those are, well, there are two House of Lords cases about tax, payments of tax. One about actually about computing or arguing with the revenue, the costs of arguing with the revenue about tax in the UK. And the other case was actually about paying Irish tax, foreign tax, and whether that could be deductible. And in both cases it was decided no, it couldn't, none of those were deductible, because they were, sorry, looking at it the two ways, either they weren't paid in order to earn profits, they were paid out of the profits, or they were being paid in a different capacity, not as trader, but as taxpayer, if you like. I'll come on to these cases, but and that was applied, this principle was applied, that's why it's quite important for this case, it was applied by the Court of Appeal in Von Glen to penalties. So it was said in Von Glen, the reason penalties are not deductible is because they're not paid in order to earn profits. They're paid as a result of trading, not as a cost of earning the profits.
So how about an employee who isn't provided with a safe place of work by his employer and who is exposed to noise, for instance, over a substantial period of time, and subsequently sues the employer for compensation for industrial deafness? Is that deductible?
Now that is a difficult case, I agree. Whether that would be, you would have to then decide whether that was a cost of earning the profits. That's a tort case you're talking about.
Yes.
That's where you get to these difficult cases, which frankly there hasn't been any clear authority on. The only authorities on tort, as far as I'm aware, are Strong and Woodfield, which is not particularly helpful.
Which one?
Strong and Woodfield. And I think it's called Theory, the case about the malicious falsehood. The malicious falsehood case, which I think is called Theory. We don't actually have that in the bundle, but it's a rather extreme case.
That supposed test, not as a result of trading, is paid as a result of trading rather than a cost of trading, seems quite an unsatisfactory boundary to try and set. It's not quite clear to me, at least, what that means in various sort of quite obvious cases, as my Lord has posited.
Yes, but it's I'm afraid it's been stated and restated over the years. Indeed, I think, see, Lord Radcliffe in one of the cases described it as part of the language of income tax.
I suppose in reality a lot of these tort cases will involve insurance, and so if the employer is insured against industrial diseases and the like that his employees may suffer from, the actual damages will be met by the insurance company. The employer will presumably seek to deduct premiums from his tax liability.
Yes.
And if you were, for example, a private bus company or a taxi company, you're almost, it's almost inevitable there will be accidents from time to time, and so you would pay insurance, well, you would be required by law to have insurance,
I'm sure that's right.
and you would seek to deduct that from your taxable profits.
Yes, I think that is possibly the reason why there is a dearth of authority on these cases, on this kind of thing. It must be pretty rare.
There's difficulties in Northern Ireland because A, some of the insurance companies went bust,
Right.
and B, you can find out who was the relevant insurer at the time that the exposure occurred to asbestos.
Yes.
And, so, anyway. it's
But
not
equally, yes.
Yeah.
It may be quite often.
Companies themselves have gone bust. You know, so it'll just be a claim of liquidation.
And then you have
I mean, they're taxable. You've got no taxable profits. Yeah, I mean, there are still people making a living in Scotland from asbestosis cases and shipbuilding on the Clyde.
Yes.
But, there are no longer any taxable profits for the damages to be deducted.
Well, that's another point I was going to make, that very often these companies have either ceased business or not, have long gone. But anyway, that's only one example.
But the time that they came under that liability, they were in business. I mean, the liability to pay the compensation happens once,
Well, I'm not sure
once
that's
the
necessarily the
symptom
case.
becomes apparent.
Well, but it's a rather complicated position under these aspects.
Yes,
because they've
yes.
been decided on a very
With the
strange
part.
causation basis, that which I think Lord Reid may know about.
Yes. Yes, I remember a case called AXA.
Yes, yeah. So I don't think it's quite as straightforward as that.
No.
They may not have actually suffered any loss at the time they
Right,
were
but
employed, but it's all a matter of causation.
So as far as this, you say that as far as breach of contract is concerned, as long as you entered into the contract in the course of your business with the aim of making profit, then damages that you pay for breach of that contract are deductible. And as far as tort is concerned, there's a lack of authority for reasons we've discussed, and the authorities they are a bit unhelpful.
Yes, but what you can't say is that they are assimilated with penalties. I mean, the reason that a tort claim may or may not be deductible is nothing to do with it being similar to a penalty, in my submission. The question would be more, was it incurred in earning profits, or asking Lord Hoffman's question about policy, perhaps, which is a more difficult question. So can I then just deal briefly with practically almost unavoidable? I don't think I need to say too much because I've already shown you some of the paragraphs. We deal with this in our case at paragraphs 38 to 39. And the first tier tribunal deals with it at paragraphs 52 to 54 and 57 to 58. And those have to be read in the light of the conclusions and the notices of decision. I've shown you the complaints handling, so perhaps I could just take you to the CO2 emissions, which is the other one, which is begins on page 307. And the relevant paragraphs are on page 316 to 317. So you can see on page 316, Scottish Power, these are the what you might describe as the excuses Scottish Power put forward as to why there was breach. And 516 records that they contracted with a third party I think the third party sort of let them down, it seems. But in the middle of 517, the authority considered that the evidence showed that ScottishPower's reasons for taking the decision were centred on budget, cost and commercial interests. The authority considered that ScottishPower was not prudent in assessing the likely impact this decision would have on its ability to achieve compliance. Further, it was questionable in the authority's view whether such a step should have been taken by ScottishPower in the circumstances. The strategy adopted with third-party contractor was not conducive to achieving compliance, and so they conclude on page 317, 5.20. In the light of the above, the authority considered that there was evidence that this aggravating factor applied. The aggravating factor, this was under the heading, factors tending to increase the level of penalty, on page 315. But in any event, our submission is it's not relevant to weigh up the degree to which the penalty could have been avoided. What is determinative, we say, is the nature of the payment made. If it had been an actual penalty to the consolidated fund, it would have made no difference whether it could have been, it was almost unavoidable, or completely avoidable in my submission. And the same is true of these payments, because they serve the same purpose, we would say, the same function as a penalty.
Of course, subject to my Lord Reed's point, and that is that if you literally could not comply with it, you therefore wouldn't be able to enforce it.
Well, I assume that those advising ScottishPower would be challenged, or ScottishPower would be challenging.
Yes, indeed.
If that was the case, it can't be seriously suggested that you cannot comply. And we know in the CO2 case, I think it's on page, is it 314? Page 314. It was recorded that I think 4 out of the 10 other companies did comply with the CO2.
Paragraph 5.3, is it? 4 out of 10.
Sorry?
Paragraph 5.3.
Yep. 4 of the 10 parties complied. So clearly it was far from impossible. Whether something is avoidable, it may be relevant as we see to considering something like tortious damages, for instance, in the Herald case. Certainly that was the way that they reasoned in that case. Can I then move on to, thank goodness, the tax provisions and how those apply? Now, the starting point is section 46(1) of the 2009 Act. That's the provision which says, in computing the profits, you start with the gap and then you adjust them in accordance with the law, essentially. Now, the respondents rely very heavily in their written case on what they call the rule, with a capital R, found in section 46(1). They assert that profits are determined by the rule, which is the accounts, and the tailpiece tax adjustment provisions are exceptional departures from the rule. I will be saying that this is not a correct characterization of section 46(1). The gap accounts are the starting point for a tax calculation. but they are subject to numerous provisions which make adjustments to those figures. There are, I think, almost 1,500 sections in the Corporation Taxes Act 2009. Sorry, 1,300 sections. And there are around 1,200 sections in the Corporation Tax Act 2010. So that's 2,500 sections. Many of those sections provide provisions which adjust, for tax purposes, the figures produced or seen in the accounts. Some of these provisions are general. For instance, the provision we're dealing with today, Section 54(1)A, the wholly and exclusively rule. There's also a rule that says that capital payments are not deductible. And that has very common application, because in most accounts you'll find depreciation. And the first thing you would do is remove depreciation, because that's not deductible for tax, and replace it with capital allowances. And there's another, no doubt, hundreds of sections in the Capital Allowances Act which provide for capital allowances at different rates under different conditions. And I think some of your lordships and your ladyships have been had to deal with capital allowances. But there's an entirely separate code for the deduction of capital payments. So there are some which are general, some of which apply only to certain types of receipts or expenses. So, for instance, the Loan Relationship Code, which tells you how to tax debt payments, debt liabilities between companies. And there are also a number of provisions which only apply to certain trades. So, for instance, there's certain provisions that apply to farming or insurance companies or various other trades. So there are many provisions. The purpose of the gap accounts is different from the computation of taxable profits. The gap accounts show, or intended to show, the true financial position of the company. As a result, all financial transactions must be included. You wouldn't be showing a true and fair view if you didn't include it. It doesn't matter what it is, whether it's a fine, whether it's a bribe, whether it doesn't matter. All of these things have to be included in the accounts, because they are showing those who deal with the company what the financial position of the company is, so that they can enter the contracts, or they can invest in the company, or they can continue to invest in the company if they're shareholders. So there's no reason to think that there's any magic in the accounts as being paramount, the figures in the accounts as being paramount, as the respondents seem to suggest in their written case. They are, in my submission, the starting point. You have to start somewhere. You have to have something to start with. And what has been chosen are the gap accounts. That has only been expressly provided for in the tax legislation since 1998. Before that, there was no provision which told you expressly where you start. But in practice before then, people did start with the accounts. Of course, in the past, there wouldn't have been gap accounts. People would have drawn up their accounts in different ways. Now, my learned friend relies on the case of Wimster, appropriately a Scottish case, for his proposition as to the primacy of the accounts. However, if we just turn up that case, it begins on page 1619, 1619. We will see that it was in fact an example of the exact opposite. was an example of a case where what was in the accounts was adjusted because of the tax rules. So, as you can see from the head note, what happened in this case was that the taxpayers chartered ships, and unfortunately the market changed so that they could see that in the future they were going to make losses because the amounts they were going to be able to subcharter the ships from had fallen considerably below what they were paying to charter them. However, that hadn't occurred in the period in question. And I think the problem that the taxpayers had was, you can see this is 1920. Well, it's 1925, but it was back, I think, to then. This was the last year in which excess profits tax was going to be levied. This was something that was levied during the First World War in order to tax what was seen as profits made because of the war, excess profits. So it was abolished, and this was the last year. The problem then was, in the following year, they wouldn't be doing an excess profits calculation, and so, from my understanding of what it says in the case, they wouldn't be able to carry back a loss to the period before, and so they were kind of left high and dry as far as excess profits tax is concerned, because although they could see that there were losses coming, they weren't going to be able to take advantage of them. So what they attempted to do was, well, what they did, and maybe also for commercial reasons, was that they included these losses in their accounts for the period in question. And the question was whether that was correct, whether they could do that. And the court said no. And we can see the Lord President on page 1625. It's in the middle of a very long paragraph beginning. The paragraph begins, "It is quite possible," you can see at the top, and about a third of the way down it begins, "He may, for instance, prefer to carry his profits forward or put them in reserve rather than consume or divide them, but they are nonetheless profits of the year or accounting period to which the accounts relate, and as such accessible to income tax or excess profits duty. After all, it is inevitable that profits should be ascertained at intervals of time more or less fixed, whether the object is to certiorate the trader of his commercial position or to submit his profits to assessment of a tax." And then at the end of that paragraph, having described what they did, he says, "I am afraid that considerations of this sort," which I think were that the, as I said, the last year of excess profits tax and that they wouldn't be able to take advantage of it, which seemed to be at the root of the appellant's case, can avail nothing against the rules of a taxing statute. And similarly, near the end of his judgment, at the bottom of page 1626, where they're talking about the way that the accounts were drawn up as being fair to one of their departing partner, fair to the continuing partners in relation to a departing partner. "I do not for a moment doubt that the bargain made with him was a fair and honourable one, nor do I doubt the balance sheet and profit and loss account were made up as they were in order to provide what was regarded as a fair basis on which the retiring partner should be paid out. But all this cannot affect the answer to the question, what are the actual profits made during the accounting period? Whatever the bargain made with the retiring partner, generous or strict, fair or unfair, the question remains the same and so does the answer." And then also in the judgment of Lord Sands, on page 1628, the paragraph beginning, "The consideration," in the middle of the page, "of how it would be prudent for a trader to act does not solve the question here presented to us as one of revenue law. Under this law, the profits are the profits realised in the course of the year. And so he goes on to describe what they did. And in the next paragraph, the case for the appellants here depends upon their ability to assimilate their shipping commitments to goods or stock. So what they were trying to argue, rather ingeniously, was that they had some kind of trading stock at the end of the year, being the contracts, being the shipping contracts, and that they had gone down in value. And the court said, no, that's not correct. That's not trading stock. You're not trading in shipping contracts. But they were arguing that because otherwise the position was under tax law that you're taxed on the profits for the year. So what this case shows is that it's not the accounts that determine the position, it's the revenue tax legislation that determines it. Now, one of the important qualifications I've mentioned is Section 54(1)(a), and that has two elements. The payment must be, or the expense must be for the purposes of the trade, which has been interpreted as meaning for the purposes of earning profits in the trade, and it must be wholly and exclusively for such purposes. And the first element derives from Lord Davy in Strong and Woodfield, and the second element arises simply from the wording of the legislation and has been the subject of numerous decisions. And the revenue says that a fine or penalty fails the requirements of these elements. The third...
Fails both of them. It fails which of the elements?
It fails the first, and if it is necessary, because there is another purpose, it fails the second, because that's not good enough, because it has to be wholly and exclusively. Even if you can identify another purpose, which is a trading purpose, it wouldn't be good enough. And thirdly, there is the principle that legislation must not be construed in a way which breaches public policy. And that's Lord Hoffman's approach we would submit to this problem in McKnight and Shepherd. Now, what we're proposing is that I'm going to deal with the Section 54(1) arguments, and my learned friend Mr. Chacko is going to deal with the questions of public policy, probably now this afternoon. And I think the idea is that we will finish by 3 o'clock, and then Mr. Goldberg can get going.
Yes.
So I was going to start with Strong and Woodfield, which is page 1548 in the bundle. And you can see the facts are set out very succinctly in the head note on page 1548. The judgments are also the speeches, I suppose, in those days are also mercifully short. Could I just ask you to read on page 1552? This is the speech of Lord Loreburn. And if you start right in the middle of the page, just above the paragraph break, where it says, "and no sum can be deducted unless it be money wholly and exclusively." If you just read from there to the end of the judgment, which is just over the page.
what was the text of the legislation that he was construing?
It was the wholly and exclusively rule.
Right, so he
It's the same. It's a
sort of
predecessor.
says
Sorry, the same provision.
he's paraphrasing it as being really incidental to the trade, which is a kind of slightly... But he's interpreting a wholly and exclusively test.
He is. That's what he refers to. No sum can be deducted unless it be money wholly exclusively laid out or expended for the purpose of the trade. That's just so that's what he's applying, and it's. I think he refers to the rule above in that paragraph. You can see.
This is a customer in an inn, and then at the top of page 1553, he says it wasn't in the character, they weren't traders, but it was in the character not of traders, but of householders.
Yeah, that's what he.
I have it.
That's what he said.
Yeah.
You always feel with this case there's something more to it than we've got here, but it does appear that he was regarding it, even though they were in the inn, possibly in the bedroom, I don't know. Then and they were injured by a chimney falling on them, but that wasn't incurred as a trader, is what he says. Lord Davy put it a different way, although I think he was perhaps expressing the same kind of idea, and it's Lord Davy's remarks that are actually quoted subsequently in subsequent cases. So if you just page 1553, if you just go down about a quarter of the way from the bottom of the page, where he says, I prefer to decide the case upon Rule 1, which applies to profits of trade and also professions. And Rule 1 is wholly and exclusively rule. I think that the payment of these damages was not money expended for the purposes of the trade. These words are used in other rules and appear to me to mean for the purpose of enabling a person to carry on and earn profits in the trade. I think the disbursements permitted are such as are made for that purpose. It is not enough that disbursement is made in the course of, or arises out of, or is connected with the trade, or is made out of the profits of the trade. It must be made for the purpose of earning the profits. In short, I agree with the judgment of the Master of the Rolls. And that passage, it's not enough that disbursement is made in the course of, or arises out of, or is connected with the trade, or is made out of the profits of the trade, has been quoted, applied in a number of other later cases. So, for instance, we're just about to look at Von Glen, which is the case about penalties. Now, the penalties in Von Glen undoubtedly arose out of or were connected with trade. I'll just take you to Von Glen. It's on page 718 of the bundle. What happened in that case was, this was a First World War case, and there was a customs regulation which provided that you were liable to a penalty unless you could prove that the goods that you were exporting were not going to find their way to enemy territory, essentially. And the problem that this company had, who were described as highly reputable and respectable company, the problem they had was that they simply didn't have the evidence to prove. It wasn't that they were actually sending goods to enemy territory. Indeed, it's probably quite unlikely they were, but the requirement was that you should have proof that you weren't. that wasn't happening, and they couldn't prove that. And so what seems to have happened was that it was brought by way of information before the High Court. This was before the days of tax tribunals, and it looks as though it was agreed before the case started between counsel that they were liable, that they didn't have any defence, and so they agreed that there would be a £3,000 penalty, and they were seeking then to deduct the penalty. And their arguments, actually, interestingly, the arguments which they were putting forward, which you'll find, I want to read them, between pages 721 and 724, are very reminiscent of the arguments being put forward in this appeal. Essentially, they were saying these are deductible, these are in our accounts, deductible in our accounts. We were carrying on, it came out of the business that we were carrying on the normal way, the trade we were carrying on. It was a result of ordinary trading transactions, which was exporting goods, and therefore it should be deductible. But the Court of Appeal disagreed with that. And you can see on page 727 the judgment of the Master of the Rolls, the paragraph beginning in the middle of that page, under that section, you can see a summary of the procedure. And then you can see in the next paragraph on 727 that these were not criminal proceedings, but the Master of the Rolls said he didn't think that mattered. It was a penalty being sued for by the Attorney General for an infraction of the law. It's paid as a penalty. And then if you turn over to page 729, just about 10 lines up from the bottom, I cannot find, and perhaps it's not surprising that I should be unable to do so, any authority in which the actual point has been considered. But there are some remarks of Lord Davy and Strong and Woodfield, which were referred, which perhaps throw some little light upon the matter. It was quite a different class of deductions which he was there dealing with, but he said, and then he sets out what Lord Davy said over the page to 730. And then his conclusion you can pick up on page 731. At the top of the page, during the course of the trading, this company committed a breach of the law. As I say, it's been agreed that they didn't intend to do anything wrong in the sense that they were willingly and knowingly sending these goods to an enemy destination. But they committed a breach of the law, and for that breach of the law they were fined. That, as it seems to me, was not a loss connected with the business, but was a fine imposed upon the company personally, so far as a company can be considered to be a person, for a breach of the law which it had committed. It's perhaps a little difficult to put the distinction into very exact language, but there seems to me to be a difference between a commercial loss in trading and a penalty imposed upon a person or a company for a breach of the law which they've committed in that trading.
Did they deal separately with what they decided about the £1,000 of costs in addition to the £3,000 of penalty?
They treated the costs were treated as the same in this case. They were treated as non-deductible along with the fine. No distinction was made as far as I can see.
But if supposing they'd been accused of this and they'd had to send somebody out or pay agents in the other country to get the proof, but they did get the proof to show that they hadn't committed it, would that then, those costs have been deducted?
Well, that's, my lady, that's exactly the point that Lord Hoffman made
Yeah.
in McKnight, where they did
Yeah.
distinguish between the two.
They did.
They did distinguish between
Yes.
the penalty and the costs. And the point about McKnight, which we'll come on to, is that the House of Lords held that the legal costs were deductible in McKnight. The point was taken. No point was taken, we can see in Glen, that there was any difference between the two.
Well,
But there was a point taken in McKnight. And that's where we have Lord Hoffman's distinguishing between the policy behind the penalty and the policy behind different policy considerations where you come to legal fees. And he made exactly the point I think my lady made, that surely you'll be able to deduct it if you were successful in your appeal and cleared your name. And it should be the same whether or not you're successful. That's what Lord Hoffman said in McKnight. So, but I don't think this is there's no consideration given
no.
separately in this case. So, Lord Sterndale, he mentions it being incurred personally, which one understand, going back to what we saw in Strong and Woodfield, that this is the kind of idea that you're paying it in a different capacity from trader. You're not paying it as a trader, but you're paying it as a, I don't know, a lawbreaker or something. Somebody who owes duties. That seems to be the way that Lord Sterndale was looking at it. And then Lord Justice Warrington, on page 5732, just in the middle of paragraph 1, he says, the first thing I desire to say about it is that, in my opinion, the question whether this deduction is to be allowed is one that must be determined by the rules regulating the assessment of income tax, and not by rules regulating what may be allowed in the preparation, either for a company, an individual or a firm, of the balance sheet or the profit and loss account. A firm or a company carrying on business may, within certain limits, treat as a deduction from its profits such sums as it pleases. But for the purpose of income tax, the deductions may be allowed from the gross profits are strictly regulated by the Income Tax Act. And that's dealing with the argument that was being put forward that, look, this has been deducted in our accounts, and therefore we ought to be able to, the accounts ought to be applied for income tax purposes. And then he goes on to consider the wholly and exclusively rule. So the difference between the two rules, one is not it's the loss provision and the wholly and exclusively provision on page 733, and essentially concludes that the wholly and exclusively rule is appropriate for some definite payment or disbursement, as there was in this case. So he's considering it on the basis of the wholly and exclusively rule, and he then goes on to, on page 734, and if you would just like to read the paragraph beginning, but although it may not therefore be a deduction, not prohibited by Rule 3, and down to on the next page, the paragraph before the end of the judgment, of his judgment. Perhaps I can just finish this case. I think we're coming to 1 o'clock. 7-3. So that the other judgment was by Lord Justice Scrutton, which he begins by saying the answer is obviously, of course, he cannot deduct it. But the top of page 736. But you can't just say that's the answer. And so he goes on page 737. And if you just read beginning about 5 lines down, I take for my guidance at any rate as to what may be allowed. Down to the end of the next paragraph.
So he also deliberately leaves open tortious payments.
Yes. He can see that it raises issues potentially. Yeah. But I think it's right to say that Lord Justice Warrington and Lord Justice Scrutton based what they say on what Lord Davy said about it being the purpose of earning profits. What you can definitely see is, though, that they are all applying the tax provision, the holding exclusively rule in the tax legislation. If that would be an appropriate time.
Yes. Thank you very much, Mr. Hewitt. In that case, we'll adjourn now and resume at 2 o'clock. Yes, Mr. Hewitt.
I was just about to take your lordships to 2 cases in the House of Lords where these principles have been applied. First of these is Smith's Potato Estates in Bowling, which begins in the bundle on page 1494. The issue in this case was whether legal and accountancy expenses incurred by a trader in contesting the amount of an assessment to excess profits tax were allowable as deductions in computing both income tax and excess profits tax. And this was a majority decision. You can see on page 1495, Viscount Simon and Lord Oaksey dissented. So I'm going to take you to the majority judgments. And if we just turn up to page 1509, Lord Porter and if you'd just like to read from the top of the page, but it is said, down to already earned and computed, which is the second last paragraph.
Yes.
Lord Porter appears to be making both points from Strong and Woodyfield. One, the character in which he pays is that of an individual, not a trader. And then also, it's not paid to earn profits. And then, if we move on to 1513, this is Lord Simmons. And it's picking it up about 8 or 9 lines down. The reason is not far to seek, he says. It is neither the cost of ascertaining taxable profits, etc. If you just read that down to about 4 lines into the next page.
So is there then a distinction between the ordinary costs of getting an accountant in to audit your accounts and produce your financial accounts, which presumably I would have thought is tax deductible, but not if there's then an argument with the revenue authority?
Yes, I think what he's saying is that in practice the revenue would allow the costs of the accounts and then the costs of doing the tax computation, simply because it follows on, although that may be a matter of practice, but not the costs of arguing about it later. That's the distinction that's being drawn. But he also bases it on he's acting as a taxpayer rather than as a trader, if you look in the middle of the page. Whatever you think of them, Murray, these are the principles that were being, my point is, they were principles that were being applied in Von Glen, and they are continuing to be applied by the House of Lords subsequently. And indeed, I think we'll see, I think Lord Radcliffe in the later case refers to the fact that these have been applied many times in many cases. And just finally, Lord Norman. Can I just take page 1515? It's the very first few, beginning with the very last few words. The reason why income tax is not deductible in computing profits is not merely the logical difficulty pointed out by Mr. Grant, that if it were, the computation would inevitably drift through the repetition of the deduction into the eddy of an indefinite process. Just to be clear, he's talking there about not the costs of fighting it, but the costs of actual income tax. And the point he's making is that would produce an infinite regression, because if you deducted the cost of income tax, then the amount of income tax would reduce, and therefore you have to change the computation every time. It would continue indefinitely. So it's logically impossible.
It's interesting the way Lord Simmons puts it on page 1513, when he, about 12 lines down, he says that, talking about the taxpayer, he's saying he would have earned no more and no less if there was no such thing as income tax. His profit is no more affected by the exigibility of tax than is a man's temperature altered by the purchase of a thermometer. Now, one might, and I suppose one might say the same about a regulator.
Exactly, I think that's right.
You know, that the trader would have earned no more and no less if there was no such thing as GEMA or Ofgem.
Yes, exactly. And equally, the trader in Von Glen would have earned no more, no less if it wasn't. If we didn't have the customs regulations, which meant that they had to pay our penalty because they couldn't prove where the goods had gone. So, sorry, Lord Norman So although he recognises that illogicality on page 15-16, he then goes on to say there is a more substantial reason than that income tax is an impost made upon profits after they have been earned, and unless the observations of Lord Davy in Strong and Woodfield, which has often been referred to and applied in later cases, are to be disregarded, a payment out of profits after they've been earned is not within the purposes of the trade carried on by the taxpayer. So, even in the case of where there is an illogicality, he says there's actually a better reason why it's not deductible, which is Lord Davy's reason.
That can't be a timing point because you may well pay damages for breach of contract years after the breach, or years after that year's profit has been calculated, but you can still deduct those, I think you say.
Yes, I don't think he's making a temporal
Yeah.
point. I think it's a conceptual point. The tax is levied after the profits have been earned and struck.
And I'm not sure it's just not restating the problem rather than proposing an answer.
Well, Lord Hoffman seemed to think that in, we'll see, well, you'll have seen already, Lord Hoffman seemed to think that, but if it is, then a lot of judges have made that mistake. And in my submission, it isn't restating the problem. There is a substantive point being made. Lord Hoffman seemed to think that just meant you didn't deduct it in computing profits, but that's profits for tax he's talking about.
Sorry, what was that again? So take me over that again, please. Sorry.
Sorry.
What did you say? I just missed.
Lord Hoffman's point was that whether it was paid out of the profits depended upon whether you deducted it in computing the profits.
Yeah.
But that's computing profits for tax. Whereas I think what they're talking about here are the commercial profits that a company makes. They're not talking about the profits computed for tax necessarily. They're saying that income tax has nothing to do with earning profits. And in other words, you do things to earn profits, the profits being what the company makes.
Well, you run an inn to earn profits. The chimney falls down on somebody in the inn, and you have a liability. And I don't follow it at all. The explanation was that was money paid out of profits that had already been earned. Well, of
that
course
was
it
out
was.
of well, yes, exactly.
But of course it was. But so what?
Yeah, I think many people have found difficulty with that particular factual example. Some distinctions seem to be clearly drawn in the minds of the whole of the House of Lords between your liability as a trader and your liability as a householder.
Exactly. There seems to be a distinction between carrying on the trade of a publican on the one hand and being an occupier of premises on the other hand.
Yes, because one of their lordships contrasted this with if the chimney had fallen into the street to a passerby.
From the flat above the grocer's shop, I think was his example.
Yes.
Then it wouldn't be
Then it wouldn't be deductible, but he was less sure about the facts, but he wasn't prepared to dissent.
I think it's the other way around. I think they were saying that if it had fallen on a passerby, it would have been even more obviously
not deductible.
Yes.
The difficulty in the case only arose from the fact that it was a customer of a pub who was injured.
Yes. Maybe that was regarded as happenstance that it happened to be a customer. It could have been anyone. Whereas the other example they give is someone being injured while they're on the train, actually. But then they would probably be liable in contract to them, I suppose.
Yes, well, he accepted the deductibility of compensation paid to the passenger injured in an accident.
Well, I'm not sure he went all the way, but he certainly suggested that might be a different case.
But for your purposes, all you need to do is to establish a rule of public policy that the words wholly and exclusively are to exclude penalties.
Well, that is...
Do you have to go... I mean, there is an abundance of various tests, but Which is the test that you espouse?
Well, we say that both would apply and both would create non-deductibility, which is not an unusual...
You say what?
Sorry, both approaches, both the Court of Appeal in Von Glen and Lord Hoffman's rather different approach, both, we would say, there's no reason, they're not inconsistent with each other, they're simply two ways of getting to the same answer in tax. And they're both supported by, well, the Von Glen approach is supported by a considerable amount of authority, and Lord Hoffman's approach is supported by Lord Hoffman, and the unanimous House of Lords, of course, in that case, who all agreed with them. But I don't think that approach has been suggested before Lord Hoffman, the public policy approach. But I'm simply dealing with the first of these now. As I said, Mr. Chacko is going to deal with the public policy argument. But our point on that is that is just as much, as I think your Lordship was saying, just as much an aspect of the wholly and exclusively provision as what we're looking at now. It's not a separate, wholly freestanding, judge-made rule that says public policy means you don't get a deduction for tax. And we would agree with the respondents that would be unconstitutional, actually, to say that tax can be imposed other than by Parliament.
Yeah. I mean, all the cases are about the interpretation of essentially the wholly and exclusively provision. And Lord Hoffman is really trying to rationalise why that provision is interpreted the way it is.
That was what we would submit, my Lord, and I hope we demonstrated by, in our case, we went through the various stages of that decision in some detail, so that I wouldn't have to do that today. But they show that the argument was all about the wholly and exclusively rule, all the way up to the House of Lords. And indeed, Lord Hoffman was dealing with one of the arguments by the Crown on the wholly and exclusively rule when he came to his public policy point. The argument being essentially what we discussed earlier, that the penalties are not deductible, therefore the expenses must be non-deductible as well, as in Von Glen. And he rejected that because he said there was a different policy involved in the penalty and the legal costs of resisting it or challenging it. But it was all about what is now Section 54.
But you wouldn't support a test that says, yes, of course you can regard this as wholly and exclusively incurred for the purpose of the trade. Yes, it fulfills that, but for public policy reasons, we're not going to allow you to deduct it. That's not your
That's not our case. I mean, at the very end of our written case, we have dealt with the possibility of that, because obviously we have to cover every possibility. But it's not our case. And frankly, I think certainly down south, you could say they fought a civil war over the question of who could impose taxation. But anyway, we say it has to be grounded in a statutory provision. So can I just then briefly just take you to the other
revolution in the colonies as well.
Sorry?
Yes. The revolution also in the colonies.
Yes. Yes, that's absolutely right. Smith's IRC and Dowdall, which is begins on page 996. I think I can deal with that reasonably quickly. This is it followed on from Smith's Potato Estate, because this was about foreign tax being deductible, foreign tax on the profits. So tax was levied in Ireland on the same profits. And the question was whether that could be deducted in computing income tax in the UK. And can I just take you to page 1004, which is Lord Oaksey. It's just a paragraph beginning on the first question. Just to clarify this, there were two issues in this case. One was whether it was deductible on general principles, and the other was whether there were particular statutory provisions that meant it was deductible. I'm not going to look at the latter point. And then Lord Reid on page 1006. Here he is dealing with the paragraph beginning, it was argued by the respondents, this is a question of fact, and therefore the decision of the commissioners on this matter is final. The commissioners, in this case, the first instance commissioners, had decided that it was wholly and exclusively for the purpose of the trade. He says, I can't accept this argument. Certain payments made by the taxpayer of such a kind that they are capable in law of being regarded as coming within this exception. No doubt it's for the commissioners to determine whether the circumstances are such that they in fact do come within it. But it is, in my judgment, a question of law whether particular payments are of a nature capable of coming within the exception, and that is the issue here. We would say that's the issue also in this case. And then Lord Reid essentially applied what was said in Smith Potato Estates, and you can see that on page 1012, just about a third of the way up, where he says, I think the matter is put beyond doubt by the reasons given by the majority of this House in Smith's Potato Estates in Bowland. And his analysis of that is on page 1014, just that right near the end, where he says, my lords, I trust I have not misrepresented the speeches, and he says he's read them over and over again, and they appear to establish conclusively the distinction between money spent to earn profits and money spent out of profits, which have been earned, and secondly, the fact that income tax and excess profits tax payments come within the latter category. So, and then Lord Radcliffe, the passage that I was referring to earlier, page 1017, he first makes the point that Lord Reedon made, that he thinks that the commissioners had erred in law in concluding that it was wholly and exclusively. You can see that about a third of the way up the page. Their views in conflict with what Lord Davy said in Strong and Woodfield.
So what page number again?
Sorry, 1017.
Thank you.
And then over the page he says, referring to, he says, there is much to be said for the criticism that Lord Davy's speech in Strong and Woodfield imposes too limiting a criterion as to what is permissible deduction by way of trade expenditure. But I do not know a wider one that is not vulnerable in other ways. And the fact is that this criterion has stood for so long and been so often applied that it has become, as it were, part of our income tax language. It led directly to the decision of the Court of Appeal in Rushton Hill and the decision of this House in Smith's Potato Estates. And then he goes on to deal with the argument that the various statutory provisions lead to a deduction. And he refers, I've never heard of this before, at the bottom of page 1018, to the Parliament concealing their intentions with more than a Baconian obscurity.
Further up,
Bottom of 1018.
further up the page, he, in the first full paragraph, about halfway through it, he says that the criterion is the purpose of which the expenditure is made in relation to the trade of which the profits are being computed. So he sees it as being a purposive test.
Yes. And the final point really to make on this is the question of duality. Because I think
they have to, I don't know whether the electricity companies have to pay an annual sum to the regulator to help pay for the costs of the regulation. But that presumably is deductible.
Yeah, yes, because that's something they need to pay in order to earn profits. They can't trade without that.
Yeah.
Rather like a practicing certificate for
Yes.
a lawyer.
Yeah.
But on the other hand, if you are fined by the regulator, you wouldn't expect to be deducting that from your profits for doing something wrong. The final point was about duality, because it is said in some way by the respondents that they had a trading purpose in paying these amounts to the regulator. But that's not good enough, of course, because it has to be wholly and exclusively for the purposes of the trade. So if there is a non-trading purpose, then you can have as many trading purposes as you like, but it doesn't help you. And we refer in our case at paragraph 121 to the case of McKinley and Arthur Young, which is a passage which is quite a useful summary of the position.
So sorry, can you give me the page number again?
Yes, sorry, it's paragraph 121. I'm just trying to find it myself. It's page 59 of the key documents bundle. You have that. Where we said, Lord Oliver says, much argument has been addressed as to whether the purpose of a particular payment falls to be ascertained objectively or by reference only to the subjective intention of the payer. Sorry, that should be intention, I think. For my part, I think that the difficulties suggested here are more illusory than real. The question in each case is what was the object to be served by the disbursement or expenses? As was pointed out by Lord Brightman, in Malalieu's case, this cannot be answered simply by evidence of what the payer said he intended to achieve. Some results are so inevitably and inextricably involved in particular activities, they cannot be said to be but a purpose of the activity. And in my submission, that chimes with what Lord Reid and Lord Radcliffe were saying in the earlier case, that even if the commissioners decide, as a matter of fact, that was what was in your mind, that doesn't conclude the question as a matter of law. So can I just finish before I hand over to Mr. Jackal? McKnight and Shepherd, as I said, we've dealt in some detail in our written case at paragraphs 92 to 104 with the various stages of this litigation. By the time the case reached the House of Lords, it was only the legal expenses that were in issue. The penalties imposed on the taxpayer had been an issue in the Commissioners and the High Court, and they had both decided they were not deductible, essentially applying Von Glen. But the Court of Appeal, I think the taxpayer only appealed on the legal expenses. It may be a sign of the times, but in Von Glen, the penalty was much greater than the legal expenses. But in McKnight, the position was the opposite. The legal expenses were a lot greater than the penalty that was imposed. And so they appealed, the taxpayer appealed, on the penalty, on the legal expenses issue to the Court of Appeal, in which he was successful. And then the revenue appealed to the House of Lords. And it was in dealing with that appeal by the revenue, you'll see that Lord Hoffman introduced his policy criteria. But all I wanted to do was just to say that we do not agree with his criticisms. While we agree with his decision and we agree with his alternative reasoning, we do not agree with his criticisms of the reasoning of the Court of Appeal in Von Glen. This is at page 1198. And you'll see that the paragraph just above C, he says he's no doubt the decision was correct, but then that they were curiously inarticulate, and he sets out some of what was said. And then he makes the point afterwards. He says, to say the payments followed after the profits have been earned is only one way of saying they could not be deducted in the calculation of profits. But in my submission, that's not a fair criticism. It restates the question rather than explaining the answer. Von Glen's case was not like Smith's potato estates, in which it would involve an illogical circularity to treat the expenditure as a trade expense. Well, first of all, it wouldn't have been illogical, but in any event, as you've seen from Smith, even though that was recognised, the House of Lords regarded it themselves as deciding it on the basis of their principle with Lord Davy and Strong and Woodfield. So, in my submission, the reasoning of the Court of Appeal in Von Glen is still is good law, and is one way that you can come to the conclusion that these are not deductible. These payments were not incurred for the purpose of earning profits in the trades of the respondents. Put another way, they were not incurred as traders, but personally, out of their obligations of a public rather than a private nature under the Electricity Act and the Gas Act. And it's not enough for deductibility that the payments arose from or were connected to trading activities. And finally, just to state the obvious, there's no suggestion that the respondents breached their licensing conditions with the purpose of earning profits in their trade. It's always been the case that they did this inadvertently. And in any event, it would have been impossible, because as we've seen, the payments are calibrated, or the penalties stroke payments are calibrated to ensure that they will always be worse off as a result of breaching the licensing conditions.
So they might have said, oh, let's not employ any more people in the complaints handling, phone answering service. We'll save the salaries, and if we get fined, well, so be it. The idea is to prevent them from making that calculation.
Yes, well, but they didn't do that in this case.
No, but
No.
in a different.
But if they did that, they might get in under what we've been discussing, but they would certainly have a problem with the public policy issues, which I think Mr. Chacko is now going to address. Shall I get out of the way?
Yes, Mr. Chacko.
Thank you, my lord. So, Von Glen and McKnight both took the view that taxpayers could not claim deductions for paying penalties. We say that neither case saw this restriction as a specific judge-made rule, saying something like, you can't get a deduction for a penalty, in the way that there's a section that says you can't get a deduction for business entertainment. If we had a rule like that, we'd be arguing about, well, what is a penalty, what's within that phrase? But that really would be judicial legislation. Rather, the judges in those cases saw this as an application of more general principles of tax law. Mr. Ewart has explained how the restriction on deducting payments of this kind follows from the rule against deducting payments which are not wholly and exclusively for the purpose of the trade, for two reasons, both because they're not paid in order to earn the profits, but are rather imposed on the taxpayer out of their profits, and because a punishment is personal to the person who's being punished, which means it's inherently a private expense and has a dual purpose, even if you enter into a settlement for commercial reasons. the cost is inherently a personal benefit to the person whose punishment it is. And so you get into the problem of mixed purpose. I'm going to address you on another principle which we say is being applied in these cases, which is what Lord Hoffman referred to when he explained this restriction in McKnight. And that's that this is an application in the field of tax of a well-established and much wider principle, what's called the narrow form of the ex turpi causa principle, that a person who has been punished cannot avoid or share the cost of that punishment by making claims under statute or civil law to escape it. I'm going to structure my submissions as follows. First, I'm going to look at the authorities and what the relevant principle is, the narrow ex turpi causa principle, against getting somebody else to bear your punishment, and explain why it applies to regulatory breaches such as the ones here. I'm then going to deal with the suggestion that it can't apply within a prescriptive statutory code, such as the tax system. I will then go to the Court of Appeal and look at what it said about the restriction on deducting penalties, and explain why they took the wrong approach. And finally, I'll address you on why this matters, which is for two reasons. One, that in this case, as Lord Hoffman explained in McKnight, allowing a tax deduction would effectively dilute the penalty. But also that these cases all emphasise the personal nature of punishment. And that's why the duality rules are engaged, because the cost of bearing that punishment is inherently a personal cost of the trader, not an expense of the trade. So if I might, I'll go first to what the rule, the narrow ex turpi causa rule is. There is a well-established principle in the law that if a person has been punished or sanctioned, they cannot avoid or share the cost of that punishment. It applies to claims in damages, and it applies to claims in contract, typically contracts of insurance. And if you go to what Lord Hoffman said in McKnight at page 1198 of the bundle.
Sorry, 11?
1198. This is page 1337 of the report at H. What he says is, the purpose of a penalty is to punish the taxpayer, and a court may easily conclude the legislative policy would be diluted if the taxpayer were allowed to share the burden with the rest of the community by deduction. This, I think, is what Lord Sterndale meant when he said that the fine was imposed upon the company personally. And these two concepts, I said there's two concepts in there. First, that a punishment is personal to the person it's directed at, and that the second is that this entails that punishments shouldn't be shared out among other people, either by getting a contribution or a full indemnity. Run through the case law on this issue. So this is what's referred to as the narrow form of the ex turpi causa principle. The wide form is that you shouldn't gain a benefit from your wrong. The narrow form is that you shouldn't be able to escape your punishment. And that's actually set out also by Lord Hoffman, and he set it out in a case called Grey and Thames Trains, at paragraph 29 of that case, which is at page 884. And it's basically the second half of that paragraph. In its narrower and more specific form, it is that you cannot recover for damage which flows from loss of liberty, a fine or other punishment lawfully imposed upon you. In such a case, it is the law which, as a matter of penal policy, causes the damage, and it would be inconsistent for the law to require you to be compensated for it. Now, Mr. Goldberg has said at 8.7 in his written case that this rule can't be applied here because ScottishPower is not seeking a benefit. Rather, the default is that they are taxed on their accounting profits, and it's the revenue who are trying to impose an additional charge by adding a sum back into their profits. And I say this approaches the ex turpi causa principle in the way that was rejected by this court 10 years ago in Patel and Mirza. Because in that case, what they had to decide was whether this was a rule that depended essentially on reliance to identify a claim which is relying on a wrong in some way, or is it a more general rule of public policy? And if I could take you to page 1376, at 101, Lord Toulson sets out what the current rule is, the passage starting at in answer to that question, and gives an A, B and C. So that's the modern form of it. And then if I take you to 110 and 111 of that decision, what he's saying there is that they're rejecting the approach that makes this a matter of procedure. So what they say is a party profiting from their wrong in some way, and would allowing them to do so be contrary to the public interest? In this case, we'd also say that the deduction for the expense is a benefit under the statute. The tax legislation allows deductions for expenses wholly and exclusively for the purpose of the trade. And that the fact that Section 54, as you've seen, is worded negatively, and that it says you cannot deduct anything which is not wholly and exclusively the purpose of the trade, shouldn't make a difference approaching these principles in the modern way, so that if it had said you can get a deduction which is wholly and exclusively the purpose of the trade, we'd be able to apply the ex turpi causa rule, but because it puts it the other way around, we can't. We'd say that that's the approach, the very procedural approach to ex turpi causa that was rejected in Pattel and Mercer. Realistically, a tax deduction is a benefit and the taxpayers are claiming it, whatever the mechanics are. Now, many of the leading cases are about serious crime, but the principle does not rely on the wrongful behaviour being criminal. The scope of the ex turpi causa rule, in terms of the kinds of behaviour that engages it, was summarised by Lord Sumption in the Apotex case at paragraph 25. That's at 1064 in the bundle.
Sorry, can you say the page number again?
1064. If you would read paragraph 25. So I'd say this extends the infringement of statutory rules enacted for the public interest. These are some of the things that Lord Sumption describes as quasi-criminal. And it's been applied to regulatory punishments. There's two cases that have done this. One is the Court of Session in Khan and Hussain, and the other is the Court of Appeal in Safeway Stores and Twigger. Khan and Hussain, Mr. Khan was approved by the Financial Standards Authority to perform various functions. He provided false information on a mortgage application, and he was then had proceedings taken against him, and he was blocked from practicing. He then sued his accountant for loss of earnings because the accountant had encouraged him to make the false mortgage application, and he said, "Well, by having my license taken away, I've lost my earnings." And Lord Eric held that this breached the narrow ex turpi causa principle. I mean, the reasoning in that case starts at page 989, but I'm not going to ask you to go through it because it just basically says that the rule applies here, applying Grays, Thames Trains and Safeway. But I think it's interesting that that's a punishment from the financial regulator in a way analogous to that in McKnight. It also wasn't an indemnity against a fine. He was claiming the loss of earnings consequent on having his licence withdrawn. So the form of punishment doesn't matter here. The point is, are you trying to get someone else to bear your punishment for you? Then in Safeway Stores and Twigger, that was a financial penalty, and there was a more extensive analysis from the Court of Appeal. Safeway was investigated by the Office for Fair
What's
Trade.
the page number, sorry?
Safeway Stores and Trigger starts, well, I was going to take you to 1484, which is
Thank you very much indeed, thank you.
paragraph 16 in that decision. So they were investigated for anti-competitive practices in raising the price of milk. They settled rather than go to a hearing on it, agreeing that they'd be penalised, but then they sought an indemnity against the penalty from their former directors. And Lord Justice Longmore and Lloyd explained this engages the narrow form of the ex turpi causa principle. That's in 16. The narrow form for the indemnity, and then also was the wider form, so they also wanted to claim the cost of the investigation, which would have been a loss stemming from unlawful acts. But one of the things that's interesting about this case is how much they use similar language to the Court of Appeal in Vaughan Glen, talking about how important it is that Safeway is personally liable for the penalty imposed on it, and that's why they can't claim it from somebody else. You get that in Lord Justice Longmore at paragraph 23, and which is on page 1486. And Lord Justice Lloyd at 37 at 1489. Lord Justice Pill then approached it in a manner, directly in a manner relating to regulatory policy, and in language very similar to that of Lord Hoffman and McKnight, says at 44, that the policy of the statute would be undermined if undertakings are able to pass on the liability to their employees or their employees' insurers, only if the undertaking itself bears the responsibilities and meets the consequences of their non-observance are the public protected, a deterrent effect is contemplated. Now, this court commented on Safeway and Bilter in the case of Bilter and Nazir. That was a 7-justice panel. 3 of the justices criticised Safeway and 4 did not. The issue that troubled them in that case was that the ex turpi causa rule was being relied upon by directors as a defence to the company on the basis that the wrongs that they had actually committed on the company's behalf were being relied on to sue them. And that obviously throws up other public policy and legal concerns. None of those concerns arise here. There's no sense in which the general taxpayer, the general body of taxpayers, is responsible for the breaches of regulation by Scottish Power and therefore ought to bear some of the cost of that. So, are the regulatory rules here statutory rules enacted for the protection of the public interest in attracting civil sanctions of a penal character, which is the language Lord Sumption used in Apotex? And we say plainly yes. Mr. Goldberg also refers to Apotex. He refers to paragraph 28, which is on page 1065. And I would ask you to read paragraph 28.
Yes.
The point about 28 is that what Lord Sumption means by quasi-criminal is the sort of thing he's already defined at 25 and includes regulatory infringements. And I say that these are not private infringements. Mr. Goldberg, I think at 1.2.1 and 8.3 in his written case, says that they are analogous to breaches of contract because they are breaches of licenses. But as Ms. Stewart took you to this morning, the first tier tribunal recorded at paragraph 4 that it's an offence to supply energy without a licence, and the standard licence conditions are required to be included in the licences under statute, under Section 8A of the Electricity Act. So this isn't a sort of private contractual dispute between Ofgem and ScottishPower. Ofgem don't sue in breach of contract, they enforce using their regulatory powers. And so we'd say this is clearly a regulation imposed in the public interest. The taxpayers also suggest the breaches are not particularly serious and therefore wouldn't engage these rules, in the sense that they were not deliberate, arose in the course of their ordinary business, which of course was also true in Von Glen, as you've seen, and were difficult to avoid. But we say it's not appropriate to get into an argument about how serious the misconduct was. The regulator dealt with that and held it was very serious. I mean, trivial misconduct would not give rise to payments of this scale. The appropriate level of penalty was in the millions, and this was never avoided or removed. We say it was paid in another way. There was nothing that reduced the amount that they would have to pay.
I wonder if it might be said that when you look at Patel and Mirza and the more recent cases in the same line, like Henderson and Dorset and Lewis Ranwell, the court has focused on whether allowing the cause of action would be inconsistent with another aspect of the law. And that seems to be the same essential point as Lord Hoffman was making in McKnight, where he asked whether allowing the payment to be treated as tax deductible would be inconsistent with the legislative policy which justified the imposition of the requirement to make the payment in the first place.
Yes, I mean, that's why, my Lord, we say that I think that what Lord Hoffman is actually expressing a version of this, of the ex-turpi causa.
Well, one might, I mean, it's not, I don't think it's strictly speaking, it's not really quite the same as ex-turpi causa, but you might say that the rationale is related.
Yes, that it's a related idea, and the idea that, particularly that being able to avoid the full effect of a punishment by claiming a deduction is wrong for the same sort of reasons as these cases have said you shouldn't be able to insure against a punishment or claim contribution from under tort. I was just going to ask, I think it's 7-3. Would the court be willing to allow us to run into some of our reply? Because I think that I may not be finished in the next 7 minutes.
Well, it's a matter for you. Your reply time is an hour. If you want to eat into it now, then I don't think that's a problem.
Yeah. So.
Okay.
So on the basis that so much, if I run over, it will be taken out of that.
Yes. Mr. Goldberg won't lose any of his time.
So is it a problem to apply this in taxation with tax being a comprehensive statutory code? And we say no, this isn't a problem, and that was rejected by this court in Welling Hatfield. That was a case about planning law. The statutory regime said that there was a 4-year time limit for infringing planning rules by changing a building its use as a dwelling. A builder obtained planning permission to build a barn. He built a barn that had a house inside it, and then after 4 years, he told the council and asked for a certificate of lawful use, saying that he had been doing this for more than 4 years, so they had to approve it. And the Court of Appeal held that that he was right. Interestingly, the Secretary of State agreed and thought this was right, but the council appealed, and this court said it would allow the builder to profit from his wrong if he could obtain a certificate through kind of deliberately sort of manipulating the statutory code in that way, despite planning being a comprehensive code. And
just wondering why it is that one needs to go into these cases, because if the policy of the legislation that we're looking at is that the individual who is to be punished is punished, why do we have to get into ex turpi causa? Why not just rely, as Lord Hoffman did, upon the policy of the legislation?
I think because ex turpi causa explains a problem which the Court of Appeal had here, which is they said, what is this principle that Lord Hoffman is referring to? Is it a sort of freestanding rule? And we say no, it isn't like there's a judicially invented rule about penalties that exists in the tax code.
He didn't invent a rule. He said that the purpose of this payment wasn't wholly and exclusively in relation to the trade. It was a personal payment fulfilling the policy of the law, of the legislation. And
I think we agree with that, but the Court of Appeal didn't. It said that it wasn't part of covered by an only exclusively principle. So this is, in a way, this is relevant for two reasons. One is that we say it would infringe at least a similar rule to ex turpi causa, in that it allows a partial indemnity against punishment.
So you mean this point is relevant if we are against you on your wholly and exclusively point, and if we say this is actually wholly and exclusively for the purposes of the trade, then as a fallback you rely on ex turpi causa narrowly, the narrow meaning to say even so it shouldn't be recoverable.
Yes.
Deductible, I mean.
Yes, I do say that. But also that the concerns in these cases about how a payment is personal to the person who's punished and shouldn't be moved to someone else explains why it is that bearing the cost of a punishment has a dual purpose. Because even if you have commercial purposes as well, as in Mallew and Drummond, there were commercial reasons for Miss Mallew to get a suit for court, it is an inherent purpose of wearing the suit that it gives you a private benefit. It's an inherent purpose of bearing the cost of the penalty that it benefits the person whose penalty it is, because it's personal to them. It can't be moved around. And that's why the other reason we think these cases are relevant, because they emphasize that that's true. That comes from the nature of a punishment. It's not something special about statutory penalties.
So, sorry, just to push that. So you say it's because of that, because of the narrow maxim, that's why it has a dual purpose, because its purpose is to take your punishment in a personal capacity.
Exactly, my lady. In a way, it's inherently a private. It's in the private capacity of the person carrying on the trade, not in the capacity of them doing their trade, because that's what punishment is. I'll give you the sections in Welling, which are just 50, where he says he will apply it even within a comprehensive code, and 53, where he says this is a matter of interpreting the statute, in that he says your Parliament cannot have intended in the planning legislation to allow you to get a benefit in this way. And that's the sort of observation that's made all the time in tax legislation when applying, for example, what's called the Ramsey line of cases, that Parliament cannot have intended you to be able to manipulate the statute in such a way. If I might now go to what the Court of Appeal said and where we say that went wrong. So if we go to page 108 in the Corban, this is the Court of Appeal's decision, at paragraph 49, So at 49, Lady Justice Falk, she cites Lord Hoffman's concern about sharing the burden of a penalty. But then at 50 and 51, she explains why she doesn't see that as an example of the wholly exclusively rule. I mean, the reason she actually gives for that we'd disagree with, which is that she says, well, wholly and exclusively is about the taxpayer's purpose or object, citing Malnew and Drummond, rather than the character or nature of the payment, which is the issue in Von Glen. And we say that isn't actually right. I mean, Malnew and Drummond was itself a case where they said that it was in the nature of paying for your clothing that one of your purposes was going to be warmth and decency, whatever you thought about it. And so similarly, I mean, Mr. Ewart took you to Lord Reid in Dowdall saying it was a question of law. The reason it's a question of law is that it isn't just a matter of what the taxpayer thinks about the expenditure. There are expenses, such as clothing, where in their nature they will have a private purpose. And we say that's the case here as well for the punishment. But then at 52 to 54, her analysis is that this is a judge-made rule, but that's all right as long as it's clear, and it's also one of very long antiquity because it dates back to Von Glen. At 55 to 56, she says it's about not diluting the legislative policy, and that must mean it's the legislative policy behind the penalty, and so it must only apply to statutory penalties. And she does note that that means that it wouldn't have applied in McLaren, where the penalty was under the rules of Formula 1. It also wouldn't have applied in McKnight itself, because that was before stock exchange rules were put on a statutory footing. And I submit that's a surprising result and suggests something has gone wrong in the analysis. That leads her to her framing of the rule in Von Glen at 58 onwards. 59, she says, such a rule exists in relation to the deduction of fines and penalties, at least where they are imposed under a legislative regime. However, there is no support in the authorities for that rule to extend to amounts which are not in fact fines or penalties. And then explains why she says extending the rule, as she sees it, would be uncertain. At 60 to 62, she identifies one uncertainty, which is she says that it can't be that simply replacing a penalty that wouldn't be deductible with something else means that other thing is going to be non-deductible as well. And at 68 and 69, these were some issues that were asked about this morning. She says, well, the settlement itself requires Scottish Power to improve its compliance. That will cost money, but they're not being forbidden a deduction for those improvements. And similarly, if they had voluntarily made redress payments to their customers before the investigation started, those would probably also reduce the level of penalty, but they probably would have been deductible. And we say that these stem from a misunderstanding of what the rule was. It's not a judge-made rule stating specifically that no fines and penalties can be deducted. Rather, it's an instance of the well-recognised principle about how you approach punishments. That's why it didn't matter that in McKnight the regime wasn't statutory. That was still the recognised way that stockbrokers were regulated and punished, and he was being punished. And you see this at 68 in her decision, where her approach seems to be that because this isn't a statutory penalty, the revenue's position must be that it's not deductible because it's something Ofgem took into account when reducing the penalties to £1. And so she will then, at 68, 69, talk about other things Ofgem also took into account and says, well, they're deductible. And we say the sequence that this gets the sequence wrong. I mean, you've been taken to the complaints handling letter, which made clear that the appropriate penalty before discounts was 23 million and then discounted to 18 million. And it's not that you then take into account redress payments to give like a 99% discount on the rest of it. That's how you meet the 18 million. It's not a further discount. I mean, this is stated explicitly when dealing with the carbon dioxide penalties, where there's a similar letter But Ofgem are asked, well, can we reduce that 2.4 million penalty further? And they said there's no mandate to do so. This is page 413 of the bundle. I mean, you'll actually see at the beginning of 4.1...
So I think you accept in 69, you accept that, yes, if they take on more people as a result of criticisms and the fines, or if they, then they could deduct that expense. And if they, we had discussion this morning, if they pay out at a very early stage of the investigation, or they pay out and get a compensation and get a reduced fine because they've shown remorse and tried to do the right thing, that could be deducted. But you don't agree that that means that the dividing line is so unclear that it can't be a rule, is that?
No, because we say that what's going on here, in those cases, that's clearly not how the regulator is punishing them. You're not being punished by being told this is the acceptable number of complaints handlers to employ. You're being told how to comply in future, and that's a cost of trading. But what the authorities have said is that the cost of your punishment is personal, and in these settlements, the 18 million is the punishment. Well, in the complaints handling, they don't escape that punishment by paying it elsewhere. The agreement is about how it's going to be met. You can't read the documents as saying, well, Ofgem, after threatening them with a £23 million penalty, decided that in light of how generous they were being to their customers, they'd get a slap on the wrist and it would be £1. The seriousness hasn't reduced. The appropriate level hasn't been affected. This is how the penalty is actually paid. And we'd say they're not being let off anything. And so that's why, unlike those other examples, this is still their punishment, which is what the first tier found at 134 to 135. And in fact, as it found at 130, it said objectively, this is in the nature of a penalty. It's suffering imposed on you because you breached the rules. Those other examples aren't suffering imposed on you because you breached the rules. And that's what the FTT meant when it said these sums took the place of penalties. It's not that they replaced them in the sense they then weren't punished. It's that this was what did the thing the penalties would otherwise do. This was the deterrent. This was the appropriate sanction. Mm-hmm. But Ofgem considered that it was more useful for their purposes that this went to customers than that it went to the consolidated fund.
It's interesting, in the discussion in the Court of Appeal, in paragraph 49, von Glane is said to have established that a penalty or fine incurred under a regime such as the one considered in that case is not deductible, even where it was incurred in the course of trading activities. And then in paragraph 58, we're told that the court recognised in NCL that a rule that denies the deduction for expenses that are not only incurred in the course of trading activities, that are taken into account in calculating profits, etc. It seems to be taken for granted in these paragraphs that we're dealing in this case with expenses which were incurred in the course of trading activities.
Well, I would say
that's I mean, it might be right or it might not, but it's not obvious.
I think it's in the sense that they were in Von Glen. In the sense that they were in Von Glen, because in Von Glen, there's nothing outside the ordinary scope of their trade when they put the goods on the ship to Russia. So in a way, and this is what's talked about in Von Glen, this flows from their ordinary trade. It comes out of that. There's a passage in...
Yes, but I wonder, the assumption that Lady Justice Falk is making, I think, is that we're dealing in this case with expenses incurred in the course of trading activities. And if that's right, that gets the taxpayer quite a long way home, but that starting point isn't really being examined.
I think, as Mr. Stewart took you to earlier, the underlying activities in the sense of paying for complaints handlers, sending people around to sell contracts.
Yes, but she's not talking about the acts or omissions that gave rise to the penalties, and she's talking about the penalties as expenses incurred in the course of trading activities.
Yes, and I would say that they're not, unless you take that meaning in the same way as in Von Glenn, which is the underlying behaviour is in the course of trading activities. The penalty isn't. The penalty is imposed, as in this is what they held in Von Glenn,
yes.
And she is quoting Von Glenn, applying Von Glenn there. The penalty was imposed as a consequence of trading activities, but I think it's put quite well by Rowlatt, approved by just dig it up.
Yeah.
Yes, if you go to page 730 in Lord Sterndale, it's where he says, of course, as Mr. Justice Rowlatt said, in a sense, you may say it was connected with the trade, because if the trade had not been carried on, the penalty would not have been incurred. There would be no opportunity for the breach of the law which took place. And that's the sense in which in Von Glenn these are incurred in the course of trading activities.
So it's not, what they're saying is it's not enough that it's incurred in the course of trading activities. It has to be wholly and exclusively for the purpose.
Yes, because that's what they're applying.
Yes, so they're contrasting that wording in the course of with the more stringent test that's required in the statute.
Yes. And so we say the actual question is this how they're being punished? I mean, Justice Falk said that there was no power, Ofgem had no power to redirect penalties away from the consolidated fund into charities and consumer redress. But we say they did have that power because what they did here was not unlawful. And that's effectively what they did. It was agreed what the appropriate level of penalty was, the breach was conceded, and it was agreed where the money would go. And this is described to the public in the agreed notices between the parties as if it's a single passage, and that's the punishment that they're getting to deter other people. And we've set out those passages on page 35 of the bundle in our written case at 29. So I'd say it doesn't matter, that's how it was described at the time. And so, on that basis, we'd say, simply as an application of the rule in Grey and Thames Trains, if this is their punishment, they shouldn't be able to get a deduction that would reduce that punishment. But also, because this is their punishment, it's personal, and therefore meeting that is an inherently private cost that brings in duality. So we'd say on either basis, the payments are not deductible. This takes us on to the final point we deal with in our written case, which is even this is a freestanding rule, we'd say the FTT was right to say it covered the payments in this case. You could partly see that by the fact that if it was as narrow as the Court of Appeal said, it wouldn't have applied even in McKnight. But if it is a rule of public policy, you have to ask what that public policy is and whether or not these payments fall within it, rather than just say it's a rule of public policy, so it must be construed very narrowly. And in this case, as is the first tier explained at 130, they looked at the nature of the payments. They said, well, these are in the nature of penalties, sort of as a matter of objective reality. and they considered what the nature of penalty was, and so would say there was no basis for overturning that. So, does that matter?
Yes, thank you very much, Mr. Chacko. Yes, Mr. Goldberg.
Ladies, my lords, I've been doing this job for about 55 years now, and it's the first time that I have come across a case where a deduction has been denied for a payment on the ground that although it wasn't a penalty, it could have been. You can go through the cases, you won't find any case that is authority for that proposition. And this court is being asked to invent it. And it's being asked to invent it after Section 46 has been enacted, and there really is no basis for inventing it. It's a bit like the lady who goes to the lecture on gravity by Professor Einstein, and after it she says to him, I was very surprised to hear that the sun holds the earth in place by gravity, because I thought everybody knew that the earth was held in place by an elephant standing on the back of a turtle. And Professor Einstein says, oh, that's very interesting. What is the turtle standing on? And she says, you can't fool me that way. It's elephants and turtles all the way down. There really is no basis for the proposition that the revenue are putting to you. There are three striking things about this case that show that redress payments should be deductible. The first is that, leaving aside any question of penalties, on the facts found by the FTT, the case for deducting the redress payments is irresistible. The commercially right answer is that the redress payments are deductible. They are a normal and, in many cases, a more or less unavoidable cost of doing business. And that is so even when the question of penalties is taken into account. On Friday, and I hope I might be forgiven for handing in these papers yesterday, but on Friday last, there was an announcement by Ofgem that it had reached a settlement with British Gas in relation to a different breach of the regulations from that in this case.
They used redress orders. They used redress orders.
They didn't use redress orders, my lord. They reached an agreement, and they did it without any penalty. And we've got the papers here which we can hand in.
But why does it matter?
Why does it matter? It illustrates some of the difficulties in my learned friend's argument, because some of the points you have been putting to him are dealt with in these papers. If we can.
How does it impact on statutory interpretation?
It impacts on whether it's wholly and exclusively for the purposes of the trade. And it also illustrates that there is that these sorts of payments can be made irrespective of whether there's a penalty or not. So that the payment has nothing to do with it. If your lordships don't want to look at it.
No. Do you have a copy for Mr. Ewart?
Oh, we provided it to Mr. Ewart first thing today.
Yeah. Well, unless Mr. Ewart has any objection to our looking at this, no? Oh, very well. Yeah.
So we see that in recognition of Ofgem's findings, British Gas has agreed to pay a 20 million payment into Ofgem's voluntary redress fund. That British Gas has agreed to a settlement package which includes compensation to affected customers in the periods 2018 to 2021. In addition to the compensation, British Gas has already proactively paid to affected customers in the period 2022-23, writing off up to 70 million of energy debt for vulnerable customers in accordance with the framework agreed by Ofgem, a proportion of which may be used as compensation for some customers, continuing to provide the remainder of a 22.4 million voluntary package British Gas launched in 2023, aimed specifically at supporting PPM customers, creating a new panel, and so on.
Can I just ask you, Mr. Gilbert, the first document we have here is, I think, Ofgem's decision.
Yes.
Then we have, is it a press release by Centrica, which is British Gas?
Yes.
And the last one, where does, is there another press release? Or where
It's
does
a press release by Ofgem.
Ofgem. Thank you.
So is the most relevant to those the decision document?
They're all relevant in showing how much is being paid away. And this case throws into question whether British Gas or someone else in the position of British Gas could get a deduction for those payments.
Yes.
My learned friend has given you, the court, no answers to that at all.
Well, so here you're saying the difference is that there wasn't the pound penalty. They don't mention a pound
Yes.
penalty.
There's no penalty.
Well, it might be said against you that Mr. Hewitt's answer would be that it's treated in just the same way as the redress payments in your case. They are all in the form of a package to punish and deter for breaches, serious breaches of the regulations and licence conditions.
Why did my clients enter into it is the relevant question under
Sorry?
the statute. The relevant question under the statute is why did my clients enter into it? Not why did Ofgem enter it?
No, sorry, you said no, there's been no answer from Mr. Hewitt as to what the position would be
Yes.
in the British Gas case.
Yes.
And I was just putting to you that it might be said against you that the answer would be exactly the same.
It might be.
Yeah.
But my response to that would be it's very difficult to see why that should be the answer when there is no penalty at all. We need to look in a moment at exactly what Ofgem said when entering into the agreements which were entered into in this case. Because they very definitely did not say, oh, we'd like you to pay a penalty of 18 million, but we'll call part of it a redress payment. What they said was, we'll ask you to pay a penalty of £1 and redress payments of 18 million less £1.
Will we fully know unless we see the without prejudice offer that came and the deductions that were made from it and so on? There's going to be a whole lot of background to this, isn't there?
There is, but you're going to see some of the background to this when you look at the documents in our case.
Yeah. So they admitted responsibility and agreed to make a payment to Ofgem's voluntary redress fund.
Yes. But they also wrote off 70 million. And if you're going to call that a punishment, according to my learned friend, that's non-deductible. And that, my ladies, my lords...
I still haven't got my head around it. They wrote off 70 million of what? Sorry?
debt.
In
They are
this document.
writing off of up to 70 million of energy debt for vulnerable customers in accordance with the framework agreed by Ofgem.
Yes.
Yeah. Okay.
Well,
It's not a question of that tax deducting that debt, though, is it?
I'm sorry. No, I'm asking the question. I'm posing the question. That sort of payment, is that deductible? You would expect, if you're a trader and you've bought in 70 million of debt, and for some reason you write it off, you would expect to get a tax deduction for it. It's very odd if you don't get a tax deduction for it, but according to my learned friend, you don't.
Well, evidently we can't. You can make what you can of this, but we can't decide British Gas's tax liabilities in this case.
No, but we can use it as an example, as it were, of the issues that arise on my learned friend's argument. So my first startling point is, when you look at the facts, and I've been diverted from it, but when you look at the facts, you're going to see that this is wholly and exclusively for the purpose of the trade, if we leave penalties out of it. And even when we bring penalties into it, it is still, in our submission, wholly and exclusively for the purposes of the trade. Secondly, HMRC are trying to tax an imagined world, not the real one. The redress payments were not penalties, and they weren't in lieu of penalties. And in our submission, HMRC can't pretend that they were, which is what they're trying to do. And thirdly, while we accept that there is a rule which prohibits the deduction of statutory penalties or payments imposed as penalties, there is no suggestion, no basis in the authorities for the suggestion that the rule has a penumbral spirit which extends it to agreed payments like the redress payments. And then HMRC have come up with the imaginative idea that the principle ex turpi causa applies in this case, which is a principle they only need if they lose on all the other points. The fact they've brought it in suggests that they know that their case is weak. In her now celebrated judgment in Hall and Herbert, Mrs. Justice McLachlan explains in a rather nice phrase that the law aspires to harmony. Unfortunately, HMRC aspire to disharmony, disingenuously claiming that they're seeking harmony, which they are not. The court has before it 4 sets of payments described as redress payments. The regulator, who is charged with the duty of regulating the gas and electricity industries, agreed the redress payments with the respondents and distinguished them from penalties. And I wonder if I can ask you to look at page 327 of the bundle. So if we look at paragraphs 1.3 to 1.6, the authority took into account that ScottishPower offered to settle this investigation and to make consumer redress payments set out in paragraph 1.6 to directly affected customers and to charities, third sector organisations for the benefit of domestic energy consumers. The authority also considered 2 representations or objections received on its proposed penalty. That's the £1. These representations or objections are discussed in paragraph 115. Having considered all the circumstances of the case, the authority considered that the consumer redress payments will be of greater benefit to consumers than if a significant financial penalty were to be imposed. Accordingly, the authority considered it appropriate in the circumstances of this investigation to impose a reduced financial penalty of £1, provided that Scottish Power pays the sum of 18 million less £1 in consumer redress on the dates and in the manner set out in paragraph 16 below, and then it sets out that 15 million has to be paid and 3 million possibly floats, but in fact went to the desired recipient. So there, and we'll see it over and over again in these documents, the regulator has made a distinction between the penalty and the redress payments. The unchallenged and agreed findings of fact made by the FTT are set out in the agreed statement of facts in the key documents file. And beginning on page 22. So maybe we should begin on page 21. The essence of SPEL's trade was selling gas and electric energy. The settlement payments to consumers and charities were a consequence of not meeting the standards required of energy suppliers. The acts or inactions that gave rise to the redress payments were part of the activity of SPEL's trade and were done for the purpose of earning income from that trade. This is a very important finding of fact, which is unchallenged. Lord Reid raised a question with my learned friend Mr. Chacko as to whether the penalty payments arose from the trade. In Herald Weekly, we see that the place to look in determining that is the root cause of the payment. And when we look at the root cause of the payment, this paragraph is telling us it's in the course of the trade. All of these paragraphs are telling us it's in the course of the trade, and they are filled out by the decision of the first-tier tribunal.
But in the course, being in the course of the trade isn't enough, is it? It's got to be wholly and exclusively for the purpose of the trade.
Well, this goes to show it's wholly and exclusively for the purpose of the trade. The first-tier tribunal found that as a fact, and it has been unchallenged.
Well, they found as a fact that it was wholly and exclusively for the purposes of the trade?
Yes, they did.
Which paragraph is that?
I think it is paragraph 1. (172) on page 160.
(172).
Yes, we found, you have to read this whole passage, but 172, we have found that the other payments were not deductible on policy grounds. If we are wrong, we would find that Section 54 did not preclude their deduction. So that is a finding that the payments were wholly and exclusively for the purposes of the trade. And you see that if we start on page 158, there is a long discussion about whether the payment is wholly and exclusively, which runs through to page 172, to paragraph 170. In the olden days, I would have read this out loud. It's,
we learned how to read some time ago.
it's incredibly important because the first-tier tribunal said, if we weren't against you on this question of penalty, we would have decided this case in your favour. And the findings of fact they made have not been challenged.
Well, is that a finding of fact at 172? Because they'd already found that the remaining payments were penalties. And I suppose what's being argued is that if they're penalties, they're not incurred wholly and exclusively for the purposes of a trade.
Yes. It might be said it's really a conclusion of law.
Yeah.
Yes, it might be said it's a conclusion of law, but all the authorities say, nearly all the authorities say, it's a question of fact as to whether it's wholly and exclusively. And unless there's some principle of law that they've gone wrong on, that is unchallengeable. And what is the principle of law that they have gone wrong on? Well, apparently, because there is some ethereal idea floating about that if this could have been a penalty but wasn't, then it's non-deductible as if it were a penalty.
Yeah. Well, the case of McKnight, which you know more about than anybody in this courtroom, having been counsel in the case, it suggests in the speech of Lord Hoffman that whether a payment should be treated as being wholly and exclusively for the purposes of a trade can depend on legal considerations as well as factual considerations.
That crops up from time to time. I was once walking with Lord Hoffman through the courts on the north side of Fleet Street because he wanted me to go and have a look at the statue of Dr. Johnson's cat that is there. And we were discussing what he was doing. He said he was writing a paper on failed judicial experiments, and he was going to use as a chief example Furness and Dawson. And I often think that what he said in McKnight might be another example. It doesn't respond to what the statute says. And it really wasn't the issue in the case. It isn't authority for the proposition. The real difficulty in this case is that the regulator did not, for the revenue, not for me, the real difficulty is that the regulator did not want these payments to be penalties. And he's made that quite clear. Can I, before I leave that, can I give the court some further references to the first-tier tribunal's decision on page 149 of the bundle, in paragraphs 94 and 95, we see a further discussion.
So what page number, sorry?
149.
149, thank you.
Where they make the point that in determining whether something is wholly and exclusively, you have to go back to the root. Paragraph 112 on page 152, is another important finding of fact.
In what way? You say it's important, in what way, sorry?
Well, if you are running a trade and it is overwhelmingly likely that you may have to make a certain type of payment in the course of running that trade, it is to be expected that it would be deductible. It's unlikely that you're going to be running a trade incurring non-deductible expenses. My Lord Reed this morning put the example of a taxi firm, and he said it's inevitable you're going to have accidents. This is saying it's inevitable that the sort of accident that happened in this case, which is that we didn't answer the telephone quickly enough.
It's not inevitable that they're going to break the law, though. Taxi firms. There's a high chance of having an accident if you run a taxi.
Yes.
Yeah, but there's not a high chance, and it's not inevitable that you're going to breach your license conditions.
No, but the tribunal found that the infraction is practically almost unavoidable.
Yeah, that's because of how they chose to run the business.
Yeah, but
I mean, I can't. It seems very odd that as a responsible business you would have signed up to a license which contains conditions that were impossible for you to fulfill. It seems very implausible to me.
well, I believe that in order to run a taxi service, you have to have a taxi license. And it is apparently more or less inevitable that you're going to have accidents.
But we're not talking about having accidents. We're talking about, for example, running a red light. Would you say it's inevitable if you run a taxi business that you're going to not stop at a red light, and therefore you should be able to deduct the fine?
But this isn't a fine. This is expressly...
Well, that gets back to the other point, but that's not the point. You're dealing with an unavoidability point here. So if you run a taxi business, you know that people tend to run red lights if they're in a hurry. Certainly, would you then say, so we should be able to deduct a certain proportion of our penalty payments for running red lights?
I'm not claiming to be able to deduct anything that is in form a penalty.
I think we were taken by Mr. Hewitt to material from Ofgem which suggested that I think 4 out of 10 suppliers had complied with all the requirements. And
Yes.
6 out of 10, including ScottishPower, had not.
Yes.
And it depended on how they ran their business.
It's a very common feature of running the business that there are these breaches.
Well, it's not a common feature if you employ enough claims handlers.
I'm sorry?
Well, but this is complaints handling rules.
Yes.
And your complaints procedures weren't sufficient because you didn't have enough people answering the complaints.
Yes.
So all you've got to do is employ some more people.
Yes, and we did. Once we discovered the point...
But it wasn't unavoidable. You could have employed sufficient people to have a proper complaints handling procedure.
Well, I'm glad your lordship knows more than the first-tier tribunal who heard the evidence.
Well, but what they were saying is that it was practically unavoidable because of the way you structured your business.
Yes.
Not that as a matter of inevitability in every business it was unavoidable. So if you structure your business in a way that is going to put you in breach of your license condition or in breach of a regulatory rule, that's a breach. It's not inevitable.
First of all, I didn't claim it was inevitable. I claimed...
Well, you said it was unavoidable.
Practically almost unavoidable.
Well,
And the first-tier tribunal heard a lot of evidence, and they agreed with that. Now, no doubt, and they didn't agree with it on everything, but they did agree with it on complaints handling. And no doubt it is a very difficult part of the business of the company. dealing with it. But in any event, the revenue have to tax my trade. They're not taxing some platonic, perfect trade. They're taxing my trade. And unfortunately, I ran into some difficulties. That happens quite a lot when you're running a business. And you hope that you've not denied a deductibility. And the first-tier tribunal makes the point that I'm being reminded I should show you the previous sentence in paragraph 112. We find that infraction of the standards is not uncommon.
That's a sorry reflection, isn't it? That's a sorry reflection on the standards in the industry.
These are... I rang British Telecom the other day and got an answer. It amazed me. They deal with millions of complaints. And that's the reality.
But do you accept that if, on exactly the same facts, it being practically almost unavoidable that there were breaches, if in fact there had been penalties imposed, then those would not have been deductible?
I think I have to accept that, yes.
Well, so the unavoidability of it doesn't seem to me to have anything to do with whether it's deductible or not. It doesn't seem to have been part of the reason why Ofgem accepted that you deal with it by redress payments rather than penalties. That doesn't seem to have been part of the reasoning at all. Oh, well, we'll give you some discount or we'll let you do these redress payments because it was unavoidable for you to have a breach. So I don't really see what relevance the unavoidability has in this matter.
It's mentioned in Herald Weekly Tribune, Herald Weekly Times, as a factor. I think as we go through the cases, we will see that the character in which you pay the sum is a material question in relation to, did you pay the money wholly and exclusively for the purposes of the trade? And in determining whether you incurred the expense wholly and exclusively for the purpose of the trade, a number of different factors can be taken into account. Can it be said that it is a payment made out of the profits after they've been earned? Can it be said that there is duality of purpose? Can you say that this was paid in a trading capacity or in a non-trading capacity? These are all factors to be weighed in the round in determining whether you have incurred the liability wholly and exclusively for the purposes of the trade. This is another factor that you take into account. Is the chance of error high so that you have to pay for the error? These are all part of the determination of whether something is wholly and exclusively for the purposes of the trade. But in the end, that is a question of fact. And all of these facts are in my favour. I think I've shown you page 152. Can I ask you to look at page 153, paragraph 119? Is a very important paragraph.
Isn't that a finding of dual purpose?
They did not find dual purpose. They found trading purposes for everything.
Yes, you rely, I think, on the last sentence.
Yes. Yes.
Oh, I see. Yeah.
Paragraph 199 refers to the purpose of closing down the investigation and avoiding adverse publicity, but there's no reference to avoiding the imposition of a penalty.
No.
Well, that was one of the purposes, though.
No, they want. The Tribunal has not found that as one of the purposes, and it isn't open to this court to find it was.
Do correct me. I thought that the first-tier tribunal did decide that if they hadn't paid the redress payments, the penalty in the same amount would have been incurred.
That is not a finding that the purpose of the trader was to avoid the penalty.
Right. Yes. Okay. And it's the purpose of the trader. Yeah.
Yes.
What about paragraph 138?
That is not a finding of the purpose of the company. You'll see that and Scottish Power had a policy of paying redress to customers. You might say all of that was designed to avoid a penalty. Is that non-deductible? The Tribunal has decided that that's deductible. It would be frankly astonishing if it wasn't.
And is it wholly and exclusively the purpose of the trader? So, for instance, the lady claiming a deduction for court clothes.
Yes.
In that case, she did have this objective purpose. She didn't want to. She was only wearing those clothes for court purposes.
Yeah.
But they went beyond that to look at the real object.
The equivalent of the first-tier tribunal, the special commissioners, found as a fact that she had a dual purpose. My tribunal did not find as a fact that my taxpayer had a dual purpose. They found it had a single purpose, and that was the purpose of the trade.
And where do we find that first-tier tribunal finding that there was a dual purpose in that case?
Oh, yeah.
I'm sorry for asking you.
Will you give me a moment?
Well, no, deal with it tomorrow.
I can deal with it in the morning. Yeah. No, that was the problem for this manager. She didn't persuade the special commissioner that she only had one purpose. And, frankly, entering into the settlement agreement isn't like going naked in the street.
Is like what, sorry? Is like what,
entering into the settlement agreement is not like going naked in the street, which was what Miss Manadoo, the choice if she wasn't wearing, well.
But would you agree that there are some payments where the question can't be answered only by looking at what the payer intends to achieve, but the results are so inevitably or inextricably bound up with what the payment is that you can look at it objectively, irrespective of the subjective views of the payer, and say it is a purpose of this activity to discharge the punishment owed, or the punishment that the regulator seeks to achieve.
I'm quite sure there are some payments where the objective facts suggest that the asserted subjective purpose is not true.
Well, I'm not talking about not true, but a dual purpose. So you've got a payment where the trader says, this is part of my trade, this is a regular incidence of my trade, I can't avoid this sort of payment having to be made. And that is true. But looking at the payment, it's so clear and inevitable that the payment looked at objectively is being made to discharge the punishment element of the regulatory activity.
Well, we haven't...
I'm not asking you in this case, but do you accept there is a principle where some payments can be looked at in that way?
I think I'm not prepared to go further than to say that may be so.
Maybe so. I'll live with that, thank you.
But, you know, I grew up in a world where we asked the fact-finding tribunal what was the purpose. And in this case, the fact-finding tribunal said the purpose is wholly and exclusively that of the trade. And that is always the question. Was the expenditure wholly and exclusively for the purposes of the trade? A question which arises in this case, given the points which the court has been putting to me, is this. Supposing HMRC had been aware of GEMA's practice of entering into settlement agreements and had gone to GEMA and asked it to stop and instead to impose penalties. HMRC could have said, go and impose penalties, that's much better for us. The evidence which we can see at page 140 of the key documents bundle suggests that GEMA would have said no. It's paragraph 30 on page 140. We accept Mr. Sinclair's evidence that Ofgem's approach changed from imposing penalties to seeking settlement agreements involving substantial consumer redress payments coupled with a nominal penalty. Thus, in 2010, some 15 million of penalties were imposed with no redress payments, and in 2019, the penalties imposed were some 2 million, but redress payments were some 50 million. This change is reflected in a number of statements made by Ofgem after 2010, where it stated that redress payments would be of greater benefit to consumers than the imposition of a penalty. And when we go through the documents that were entered into, which I'm afraid we'll have to do, we will see that that is a refrain that runs through them.
Just before leaving, doesn't section 54(1)(a), I haven't got it up in front of me, refer to the purposes of the business, not the purposes of the trader?
Yes. Yeah. It has to be for...
And so the subjective purpose of the trader isn't determinative. It's the object of the exercise that's looked at.
It's material, though.
It's material, but you still have to define what the purpose of the transaction was, rather than the purpose of the trader.
I think the FTT has said the purpose of the transaction was to make profits.
The finding in paragraph 35A is that one of ScottishPower's reasons for the settlement was that settlement avoided the risks inherent in litigation, the possible adverse effects on its reputation of a large penalty.
Yes.
So the large penalty and avoiding it was one of the reasons why the settlement was reached.
Well, that doesn't mean it's the purpose of the payment.
Doesn't it?
I don't think it does, no. Anyway, why is this not the purposes of the trade?
Well, that's a different point. You seem at the moment to be saying it was no part of Scottish Power's purpose in making this payment that they thereby avoided the imposition of a penalty, and that's why you say it's not in lieu of a penalty. Now, that's a different point from saying, well, even if part of the purpose was to avoid a large penalty, then that's still a purpose which is wholly and exclusively for the purpose of the business. Those are two subtly different points, I think. Now, are you making the first of those points, or are you only making the second of those points?
Sorry, can you put those points to me again?
You seemed to be saying that it was your case that it was no part of Scottish Power's purpose in making the redress payments that they thereby avoided the imposition of a substantial fine. Is that what you're saying?
No, I'm saying it was no purpose of Scottish Power was other than a purpose of earning profits for the purposes of the business. And that is different.
Now, Mr. Goldberg, I see we're past 4 o'clock.
Yes.
Is that a convenient moment?
It's a very convenient moment. And I will
thank you
come
very much.
armed with Molyneux and Drummond in the morning.
Incidentally, I think I can save you some trouble overnight. In the Molyneux case, I think the findings of fact you were referring to are at page 1152, and they are as you submitted.
Thank you very much.
Very well. We'll adjourn and resume tomorrow morning at 10:30.